sympathetic audience, and that lawyers, however conscientious, are no different. I was therefore slightly concerned to be driven from my slot immediately after lunch to make way for learned counsel from whom you've just heard. But I hope that I'm still roughly in the 65% territory and not in the nil territory. I'm going to speak to you for more than 6 minutes, but not for a very long time, about dissenting judgments. How is it that dissenting judgments have come to be a feature of our common law legal system? What role do they play? What role ought they to play? Should they be encouraged or should they be resisted wherever possible? What use should practitioners put them to when we read cases? And also I want to say something very briefly at the end about the style in which they're delivered. Now, most of us would say, I imagine in this room, that there is nothing remarkable about the fact that when a court comprising several judges decides a case, it is generally open to any judge to give a separate judgment explaining why he or she does not agree with some aspect of the majority's reasoning. Either a dissenting judgment, properly so-called, I would have allowed this appeal, not dismissed it, or a concurring judgment, I'm going to agree with that we should allow the appeal, but I get to this destination via a different route. These sort of judgments are, of course, a common feature of judicial decision-making across the common law world and, of course, in the United States. But if we lift our eyes for a moment from the common law world, we find that it's actually a comparatively unusual thing. In France, in Belgium, in the Netherlands, Italy, and indeed across most of the civil law countries of the world, dissenting judgments are not merely not the practice, they are positively prohibited. The court must deliver a single judgment, a single statement of its reasons. And particularly in the French tradition, the judgments are terse and assertive, and they rely quite heavily on the repetition of identical verbal formulae. And this goes back a long way. Indeed, around about the time that Christopher Columbus was setting off in the direction, though he didn't know it at the time, of this island, there was an ordinance of Medina Sidonia in Spain which provided that any judge who did not agree with the majority decision could make a note of this fact. It was called a voto reservado, but only in a secret book that was never revealed. In other civilian jurisdictions, dissenting judgments are permitted, though they're scarcely encouraged, at least in the dedicated constitutional courts, which are a feature of many of the continental jurisdictions. For example, most of the cities and states which now make up Germany did not permit dissenting judgments. And when in 1877 the Germans came to draw up the rules for the courts that would rule in the newly unified Reich, they thought about whether dissenting judgments should be allowed, and they appointed a commission to decide this and other questions. But the commission rejected it, and their reasons are quite instructive. One was that the publication of dissent would be incompatible with the authority of the courts and good relations between the judges. Another was that it would foster vanity and disputatiousness. Well, dissenting judgments are nowadays, as it happens, allowed in the German Constitutional Court, but the single judgment is still very much the norm, and indeed in the ordinary courts, across almost the whole of continental Europe, with a couple of exceptions, no dissenting judgments are allowed at all. Why is it that the common law jurisdictions are different? It's tempting to think that our willingness to entertain the possibility of judicial dissent in some way derives from some fundamental difference about our societies. One might perhaps detect something of a correlation between those jurisdictions which routinely permit dissenting judgments and those jurisdictions which have enjoyed long political stability and the rule of law. But that would be a more sweeping claim than I'm qualified to make, and I'd hesitate to make it, especially in present company. But there are, and there are anyway, plenty of aspects of our system of government which, as it were, tell the other way. We don't, for example, permit open dispute, or at least not usually, amongst members of the cabinet. Members of the cabinet who get outvoted are not expected to issue dissenting opinions showing why they don't agree with the government's policy. A more modest claim is that the prevalence of dissenting opinions, dissenting judgments in our courts is, at least in part, a product of history. It results from a phenomenon which is perhaps similar to that about which Winston Churchill commented in 1943. He was talking in the House of Commons about why he thought Britain should resist the temptation to rebuild the bombed-out House of Commons, which had suffered a direct hit from a German bomb, in a different shape, in a semicircle, for example, like is common on the continent of Europe. And he famously said, "We shape our buildings, and afterwards our buildings shape us." Well, what has dissent got to do with that? Well, dissent self-evidently only arises at the appellate level, where there is a multi-member court. I suppose single judges sitting alone have their own internal dissents, but they've got to make their mind up in the end as to what they're going to do. And most common law appellate courts are, in historical terms, a relative novelty. The Court of Appeal in England was only established in 1875 in order to replace an assortment of other appellate courts, which had only themselves been set up piecemeal earlier in the century. But there was, of course, a much earlier form of appeal, namely to petition the king in Parliament, and that went back to the 13th century. Now, skirting over a lot of arguments in history, we come to the position that by about the 18th century, petitions to reverse judgments at first instance from England, Scotland and Ireland were coming from time to time before the House of Lords. Nobody appears to have thought to devise a special procedure for these cases. The constitutional fiction was that one was not dealing with a court at all, at least not a court in the ordinary sense. I suppose it was the High Court of Parliament. But one wasn't dealing with an ordinary court, but simply with a motion being debated in the House. And the cases were simply debated like any other subject on the day's order paper, albeit with the advantage, if you can call it that, of argument from counsel standing at the bar of the House. And each lord who was participating would simply give a speech setting out his own view of the outcome and why that should be the case. There was no such thing, in other words, as a judgment of the court. And of course that practice continued, albeit formalised by the creation of a special class of non-hereditary lord, the law lords, who sat on a special committee, the appellate committee. It continued right up until 2009, when a government with not much time for constitutional fictions swept it all away and created the Supreme Court of the United Kingdom instead. So in those circumstances, going back to the 19th century appellate courts, it's not surprising that the judges of those courts, and of course around the world where courts of appeal were set up in the common law world, took it for granted that their role involved each of them delivering an individual judgment, even if only to say, I concur. Thus it was, to go back to my Winston Churchill analogy, we shaped the institution, and the institution then shaped our practice. Now there are and have been, of course, exceptions to that. In criminal cases in England and Wales, the Court of Appeal is bound by statute to deliver a single judgment of the court in almost all cases. More fundamentally, there were those cases in which no appeal lay to the King in Parliament, because the place from which the appeal came was not part of the Kingdom of England. And I have in mind places like, for example, the Isle of Man, which, if you want to know what the Isle of Man looks like geographically, it's, for those of you who don't know, it's Tobago, sort of rotated about 90 degrees and moved to the Irish Sea, and minus a few palm trees as well. But places like that were not part of the Kingdom of England, but nevertheless one could petition the king, but one did so by petitioning the king in council. In other words, the king, who was in theory advised, though in practice, except in the distant past, told by the Privy Council how to dispose of the appeal. Once again, it was really an appeal to a court, but one pretended otherwise. And this arrangement, as you of course all know, spread around the world, covering at its zenith about a quarter of the world's population. And it was put on a statutory footing, of course, in the 19th century by the Judicial Committee Acts. The countries to which it now applies, of course, are fewer in number, but needless to say, not in importance. Now here, of course, the constitutional fiction worked the other way around, because it would hardly do for the monarch to receive conflicting advice as to how to determine a case. So the convention grew up that there had to be a single report of the board, so there were no dissenting judgments. That didn't mean, of course, the judges actually agreed, and indeed, just as in medieval Spain, there was in practice a sort of secret book that people who didn't agree could sign. In 1877, somebody leaked to the press the extraordinary, amazing fact, it was thought, that some Privy Councillors had not agreed with the majority's decision on what, to our eyes, seems the most extraordinarily obscure case. It was a case about what vestments a vicar might lawfully wear while he was presiding at Holy Communion. Anyway, this was all sufficiently exciting for the press that somebody leaked a report of that to the press, and this prompted an order from 1878 expressly forbidding publication by any man, I'm quoting, publication by any man, how the voices and opinions went. And remarkably, that order remained in force, despite quite a lot of protests, especially from the Australian judges, for whom it didn't suit at all, until 1966, when there was a fresh order made which said that any judge who dissented in the result could explain why. And within weeks, the Judicial Committee saw its first dissenting judgment, and there's been a steady flow of them ever since, and indeed of concurring opinions too. Although, in fact, as far as I can see, strictly speaking, concurring opinions are still not allowed. But anyway, they're given all the same. Another possible explanation for the prevalence of dissenting opinions in the common law world, I think, relates to the career path of the typical judge. On the continent of Europe, it is not uncommon to find men and women who are in their 20s who have gone in at the bottom of the judiciary and are, as it were, working their way up through the judicial firm, learning the ropes as they go. Judges in the common law world, of course, have often worked as lawyers in the private sector for many years before moving to the bench, and their personalities are likely, one might say, to have solidified by the time they get to the bench. and it's obvious which arrangement is less likely to produce judges who feel obliged to go along with what the others say. Not to say, of course, there aren't exceptions to that. Judges trained in the civilian tradition who are not at all afraid to dissent, and one of them is sitting in the room at the moment, of course. Now, if those are some of the reasons why we have dissenting judgments, the question still remains, what are they for? Should judges feel any inhibition about giving a dissent and only do so if consensus proves really impossible? Or is the right approach for the judge simply to set out what he or she thinks, not to worry too much about what everyone else says? Oddly, for what might think are rather important questions about the nature of the judicial function, there isn't really very much guidance. And naturally, such views as I offer with an extreme diffidence, born, among other things, of the fact that I am not a judge. I am, as it were, very familiar with the end product of their work, but not with the manufacturing process, or indeed with the pressures under which judges labour when they're doing that manufacturing. But as for what dissenting opinions are for, I think there are at least two answers. One is simply the possibility that the possibility of dissent permits judges to state honestly what they think about the case. A judge who dissents doesn't necessarily have any agenda, but simply is not prepared to believe that what he or she considers to be the errors of the other members of the court are not in fact errors, and so sign up something that he or she doesn't agree with. But a second answer is that in many cases the judge who dissents hopes, of course, one day to change the law. An American who became Chief Justice once said rather portentously that a dissent is an appeal to the brooding spirit of the law, to the intelligence of another day. One thinks perhaps of Lord Atkin's celebrated 1942 dissent in the Liversidge and Anderson case, refusing to agree that the court was unable to review the reasonableness of the minister's belief that the plaintiff was a hostile person, in quotes, who could therefore be indefinitely detained by the government, and declaiming in words which of course would become written in every public lawyer's textbook in the future, that in this country, he said, amid the clash of arms, the laws are not silent. Something which no doubt will be pressed upon the courts when the cases about states of emergency come before them. But sometimes, oddly enough, it's the other way around. In fact, the dissenting judge holding out against a tide which is firmly going the other way. Consider, for example, Sir Gerald Fitzmaurice, who was the British judge on the European Court of Human Rights at the time in 1978, dissenting in a case in which the European Court of Human Rights held that the Isle of Man, there it is again, could no longer use the birch on its young miscreants. No boy at the school he had gone to, Sir Gerald confided, had ever felt the least bit degraded by being caned. So anyway, the tide moving the other way as far as that one was concerned. The other judges not agreeing with that as a reason for preserving the practice. Now, while the appeal to the intelligence of another day, so-called, might mean an appeal to another day long in the future, it's not always so. In a case in 2004 called Cartwright, the United States federal government wanted to extradite certain defendants from the Bahamas to face drugs trafficking charges. The US had an overwhelming case and they got their order for committal. The defendants applied for habeas corpus, and for good measure they threw in an application for an order of certiorari to quash the order for committal. Now, the judge, for highly technical and, it must be said, plainly erroneous reasons, granted habeas corpus and ordered the defendants' release. He made no order on the certiorari application, but he did say in passing that the orders for committal were void. And the United States appealed. The trouble was that in the Bahamas, at the time, there was no right of appeal against a successful habeas corpus application. The position there was as it had been in England until relatively recently. And the Court of Appeal got around that by saying, well, the judge had, I quote, based his decision on judicial review, and that since both sides had a right of appeal against judicial review decisions, they had jurisdiction to entertain an appeal and reverse the order, and the defendants stayed in jail. Well, in the Privy Council, where it went to next, a majority agreed with that, adding that they were adopting a, quote, purposive and dynamic interpretation of the law to make extradition work effectively. Well, Lord Hoffman and Lord Roger would have none of that. They gave a joint dissenting judgment, and I commend it to you if you're interested in this subject. It's a model of the genre, for those of you who don't know it. As they put it, the interpretation given by the majority to the judgment of the judge means that not only did he, presumably on the authority of Molière, if you look at my paper online when you see it, I've tracked down what they were talking about there and given you the reference in a footnote for those of you whose familiarity with French theatre is not up to the mark. Mine wasn't, certainly, until I looked it up. Not only on the authority of Molière did he make an order of certiorari without realising that he was doing so, but that he did nothing else. The notional order is conjured up, they said, in order to be set aside on appeal, and this being accomplished, the actual order, against which there is no right of appeal, vanishes in a puff of smoke. People, they said, facing extradition, however unmeritorious they are entitled to the law. Now, exactly the same point cropped up again in 2007, so 3 years later, in a case called Gibson, when a co-conspirator brought a separate appeal against the Court of Appeal's order. And a 7-judge panel of the Judicial Committee agreed unanimously with the view of the dissentients in the earlier appeal. The Judicial Committee agreed to depart from the earlier decision and allowed the appeal. So the dissenters in the first case were vindicated within the space of 3 years. But in fact, the second case itself included a powerful dissent, this time on the question of the law of precedent, because 3 of the 7, including ironically Lord Hoffman, who had been the author of the ferocious dissent I just referred to, would have followed the erroneous decision in Cartwright out of respect, they said, for the principle of stare decisis. Now, although that's a subject for another day, we may expect, I think, it to be a recurring theme, both in the Judicial Committee and indeed before the Caribbean Court of Justice. Indeed, a judgment is, as I speak, awaited from the Judicial Committee on a Trinidad and Tobago case called Hunt, in which the state, encouraged by a powerful dissent, and I can say that with some authority, having drafted the submissions, is appealing against, or rather inviting the court to depart from its ruling in a case called Ramdeen, as recently as last year, about its powers in death penalty cases. So when ought a judge to dissent? The starting point, I would say, is that dissents ought not to be entered into, as one says, of marriages, lightly or unadvisedly. The law, after all, is complicated enough, and if, in a way, one might say, if it is not necessary to dissent, then it probably is necessary not to dissent. Certainly this is true of the concurring opinion, which goes along the lines, I agree with the result, but not the reasons. In a system governed by judicial precedent, it is not helpful for the rule of law for Judge 1 to say, I allow the appeal for reason A, Judge 2 to say, I allow the appeal for reason B, and Judge 3 to say, I agree with both judgments, or I agree with neither judgment. As the late Lord Bingham put it in his great book, The Rule of Law, whatever the diversity of opinion, the judges should recognise a duty to try to ensure that there is a clear majority ratio. But in my view, it goes no further than that. None of us, I expect, is likely to be much attracted by the 19th century German view that the authority of the court is diminished by accepting that some questions are difficult and that judges, being human, sometimes disagree. The contrary view would be reminiscent, I think, of the justification now largely rejected in the common law world for the old offence of scandalising the court, namely, effectively, that people couldn't be trusted to know too much about the judge's failings and the process of doing justice. More practically, I think a court which strives to attain consensus on every point is likely quite often to be a bad court. And that indeed is verifiable if one tries to read, as we in England have to do, though you happily don't, the judgments of the Court of Justice of the European Union. In theory, giving answers to questions about EU law from national courts. There, dissenting judgments are never permitted. So one never knows for sure whether the decision was unanimous or a close run thing. But one suspects that often there has been an effort to accommodate everyone's views. And Lord Neuberger, not altogether diplomatically, has said in a recent talk on this subject, he says one only has to look at some of the judgments of the court in Luxembourg to see how compulsory unanimity can result in decisions which, 1, are incomprehensible, 2, have internally inconsistent reasoning, 3, do not answer the issue that has been referred, or 4, manage to enjoy all 3 of these regrettable characteristics. I think his view is fairly clear. I think I would be risking the fate of an Israeli convict just before lunch if I were to attempt to make that criticism good with too much citation. But the sort of thing he might have had in mind is perhaps the court's recent decision in a competition case, which I happened to have to look at a while ago, called Expedia. It was about Article 101 of the treaty, which invalidates agreements which have as their, quote, object or effect the restriction of competition. And in the course of its judgment, the court said that this only applied, quote, where that agreement perceptibly restricts competition within the common market. But then it appeared to change tack further on, as you read through, stating that an agreement, quote, with an anti-competitive object constitutes by its nature, and independently of any concrete effect that it might have, an appreciable restriction on competition. So you get, as it were, both the majority judgment and the dissent all in the same single judgment of the court. It's interesting, but perhaps not very helpful if you're trying to advise your client what the law is. Now, even if that might be an extreme consequence of consensus, it does seem to me that the prospects of first doing justice in the individual case and secondly improving the law as a whole are promoted more by a general willingness on the part of each judge to speak, or as often nowadays to write, for him or herself, whether in concurrence or in dissent, than they are by any feeling that the objective is to get to consensus. As regards the chance of doing justice in the particular case, there are, of course, very many appeals, particularly in the Court of Appeal level, which are straightforwardly unmeritorious or perhaps wholly unanswerable. In those sort of cases, of course, it does make a lot of sense for the court just to give one judgment, whether it's a composite judgment or one judge saying what he or she wants to say and everybody else agreeing. But I think where the point is one of difficulty, there must be a real advantage, if the judges have got time to do it, in each judge attempting to put the matter, however briefly, into his or her own words. And I say that because, by and large, I think sound reasoning tends to write itself. Bad reasoning very often doesn't. And I think we'll probably come across this phenomenon if we've got experience of trying to draft a skeleton argument or write a letter to the other side in correspondence, where you're really trying to express what fundamentally you know is a bad point. It's quite hard to get it down on paper. It's generally harder to do that. I think it's harder to do than writing a good point. So one quite good way of getting to test whether your judicial colleague, I would suggest, is saying something which is correct, is to try and express it in your own words. I wonder whether that approach might have worked in two recent English cases about immigration. They were called Mirza and Sapkota. In the first one, the claimant's argument was that when the Home Secretary turned down his application for leave to remain longer in the UK, as she had done, she was obliged at the same time or shortly afterwards to exercise her statutory power to direct that he be removed from the country. And that she hadn't done. That was the complaint. The reason for this rather counterintuitive complaint, that she'd acted unlawfully by not trying to evict him from the country, was that the mere refusal of further leave was unappealable, whereas the direction for removal carried a right of appeal to a specialist immigration tribunal. And there the claimant could argue that his human right to a family life, which, as you know, is very controversial in the UK these days, would be infringed by being removed. And so he could try to get to a stage where he couldn't be removed, and hey presto, he'd be back in the position he should have been in, he says in the beginning, where in fact he was given leave after all. So the Home Secretary, it was said, was obliged to exercise her apparently discretionary removal power so as to facilitate his access to the tribunal. And one judge in the Court of Appeal, in a 47-paragraph written judgment, accepted that argument. The other two judges simply said, I agree. In the other case, that argument was taken even further, and the point was, the argument was this: if the Home Secretary made an order refusing leave to remain, without at the same time making this removal decision, which the earlier case had said had to be made, then the order refusing leave was itself unlawful. And one judge, over 125 paragraphs of written judgment with 83 footnotes, accepted this argument. Another dissented. The third, without giving any reasons of his own, simply said he agreed with the first judge. Now, I suppose the arguments had a superficial attraction, but with all respect to the judges who accepted them, both were bad ones, and I'm protected in saying that by the fact that the Supreme Court shortly afterwards held so in a short and pretty withering judgment on the subject. When Parliament had said that the minister may decide to remove somebody, it was pretty hard to see that it could have meant that she must do in certain circumstances. And yet one judge in each case had managed to write a judgment which concluded that these bad arguments were good ones. I might, of course, be grievously wronging the judges who merely said, I agree, rather than setting out their reasoning for themselves. Perhaps they'd written a long draft judgment and then not bothered delivering it because there wasn't a point, because they agreed with the judge. But if that wasn't the case, I do wonder if the Supreme Court might have been saved some trouble if only there had been an attempt to write a concurring judgment. But why do I say that multiple judgments, including dissenting ones, are good for the law? It's a related point, I think, but it's because I think soundly based principles are likely to be capable of being explained in more than one way. And if a principle has been so explained, and indeed the arguments against its being the right principle have also been explained, then a court which comes to the problem later has a much better chance of understanding the underlying principle than if it is simply confronted with a unanimous sort of quasi-legislative pronouncement as to what the law is. This comes back to a point that one of the speakers made earlier about trying to understand the underlying principles that apply rather than simply looking at the superficial level. And examples of those sort of quasi-legislative statements crop up quite a lot in the case law of the European Court of Human Rights in Strasbourg. Even though it does permit dissenting judgments, in practice its judgments are on somewhat similar lines to the European Court of Justice. Some years ago, for example, the court was asked to rule whether it was an infringement of Article 5 of the Convention, which protects the right to liberty, except in certain enumerated cases, for a man to be detained in a super high security mental hospital, Broadmoor, rather than the more liberal establishment for which his doctors said he was now suitable. And the court said that while it is accepted that there must be, and I quote, some relationship between the ground of permitted deprivation of liberty relied on and the place and conditions of detention, Article 5 was really, they said, about detention or no detention, not about conditions of detention, and so his claim failed. But that formula that they put into their judgment, some relationship between the ground of permitted development and the ground of permitted deprivation of liberty relied on and the place and conditions of detention, has gradually acquired a sort of life of its own in the cases. And it's been applied over and over again, somewhat mechanistically, in cases where really the complaint was about the conditions of detention. So the court has effectively executed a sort of 180-degree turn without ever actually saying that it's done that, simply by reapplying this formula over the years. And as a common lawyer, one wants to read a judgment where the judges really debate what the underlying principles are and how they apply. There are, of course, many other arguments in favour of dissenting judgments. As judges have pointed out, sometimes in articles and elsewhere, the need to respond to a dissenting judgment can often improve the quality of the majority judgment. It can force the judges to hone their opinions. And dissent can also curb the majority from making over-expansive claims. And, of course, in principle, one might say it's simply positively healthy for the fact that judges disagree about these things to be acknowledged and to be there on the face of the record. What about practical uses, though, for dissenting judgments? Except in those cases where we're actively trying to get a court to agree with the previous dissent, should we read them at all? I would say that we should. A majority judgment is likely to contain the facts, the legal background, the reasons for the decision. But it's very often by looking at the dissenting judgment that we get a direct route to the essence of the majority reasoning. Reading that can highlight, perhaps more easily, in fact, than reading the majority judgments straight off, not that I'm saying you shouldn't read them as well, the key point on which the case turns, and that's what it's really about. And indeed, often the essence of a particular subject can be quite well discerned from the dissenting judgment. So, to take some examples that you've already heard about in this conference, it seems to me one could make quite a good argument that Professor Just's paper makes the point that if you want to know more about legitimate expectation, study Lord Browne's dissent in the Paponet case. Robert Strang's paper suggests that if you want to know more about the meaning of a threat to the life of the nation, look at what Lord Hoffman said dissenting in the Belmarsh case. Similarly, you heard from James Guthrie, QC, about judicial bias. Well, why not study what Lord Browne said in dissent in the Baileys case? Indeed, one might even say, although it's perhaps stretching it slightly, that, as Peter Knox reminds us, if you want to know about the Magna Carta, read what Pope Innocent III thought was wrong with it, and that will tell you exactly what was right about it. The final thing I want to touch on, returning to my rather presumptuous advice about dissenting, is the question of style. How should one go about it? If I'm right to say that dissenting, like marrying, is something which is not to be done unadvisedly or lightly, then I suppose it might follow that when it is done, it should be done reverently and discreetly, if not necessarily in the fear of God. Certainly that's the common law tradition. Mr. Justice Wilson, who was then a relatively new first instance judge, was brought into the Court of Appeal a few years ago to make up the numbers in an appeal. And I think he got it right in a case called Metcalfe. He said, "Notwithstanding my profound respect for the two senior members of this court, ... and then went on to explain why they'd got it completely around their necks. And must presumably have been not entirely displeased to have been vindicated when the case went to the House of Lords, and his view was the basis of the decision that the House of Lords took. There is, of course, a certain amount of what the Germans might call vanity and disputatiousness, to go back to their 19th century criticism of dissenting judgments, and dissent can be pointed, and it may not, perhaps, for example, have been strictly necessary for Lords Hoffman and Roger to allude to Molière in explaining why the majority had got it wrong in the Cartwright case, but by and large, I think that we can say in the common law world the tone is quite civil, and so should it be. Not so, of course, in the United States, which here, as in some other respects, performs, I think, that great nation's occasional role of serving as a living warning to other countries about how things might go wrong if they're not careful. I'm not an American constitutional lawyer, of course, so it's not my place to say whether Justice Scalia was right or wrong to disagree with the majority decision in the United States in Windsor, which was the case about same-sex marriage, nor indeed whether he was right to feel highly provoked by that decision. But I do hope that we do not see a day in England or in Trinidad and Tobago when the minority feels that it has to accuse the majority's reasoning of being jaw-dropping, bearing no resemblance to our jurisprudence, and of amounting to little more than a disappearing trail of legalistic argle-bargle. If it gets like that, I think we know we are in trouble. Thank you.
Thank you, Tom. That was both informative and entertaining. And coming from the land of hyperbole, I couldn't help but pay particular attention to it. Actually, I've always had a special interest, indeed a sympathy for dissenting opinions. I attribute that to another former professor of mine. I've already mentioned a couple, but Sir Karl Popper used to teach us that we actually learn not from getting it right and truth to truth, but by our mistakes and getting it wrong. And so I've often been tempted to turn, as I read my newspapers, backwards, starting with the sports and man's achievement and going forward to where man's failings. I often start with the dissenting opinions, not just for the reasons that you gave, which I thought were very good ones, but for that reason as well. Well, again, bursting with pride, I'm going to invite two more rising stars from three-hair court to the platform, Hafsa Massoud and Rowan Pennington-Benton. If you could join me here on the stage, and I'm going to once again truncate my introduction of them and refer you to the bios that you have, but you'll see that Hafsa has a broad-ranging practice, which is public law oriented and civil law oriented, and includes a developed human rights practice. And I particularly want to brag about the fact that she has co-authored with a former head of Chambers of Three-Hair Court, a very important book that Oxford University Press has published on the protections of religious rights, law, and powers. Rowan is, again, someone who, both of these speakers have experience of this part of the world and or have great interest in this part of the world. And Rowan is another one who has undertaken public law and human rights cases as part of his ranging practice. And I think they're going to both talk to you now about constitutional damages. I'll turn over to you.
Thank you, Jeff, and good afternoon, everyone. Rowan and I will be looking at the contribution of the Caribbean to the development of the remedial landscape in constitutional law, and in particular the development of the remedy of damages for infringement of fundamental rights provisions. Now, as it happens, many of the seminal cases in this area on the issue of constitutional damages are from Trinidad and Tobago. I will begin, I hope briefly, by considering some of these cases and charting the development of the jurisprudence in this area. I will then hand over to Rowan, who will consider the influence of this important jurisprudence in other Commonwealth jurisdictions. Now, starting with the relevant provision of the Constitution of Trinidad and Tobago, the relevant provision is Section 14, and this is a provision which has received mention a number of times this morning. And it provides that an applicant may apply to the High Court for redress for contravention of the rights enshrined in the Constitution. And the High Court may make such orders, issue such writs, and give such directions as it may consider appropriate for the purpose of enforcing or securing enforcement of those rights. Now, this provision, or to be more accurate, the predecessor provision in the Constitution, felt to be considered in the case of Maharaj No. 2. Now, it would be a stretch to say that this is a recent decision, but as Mr. Maharaj rightly described this morning, this is a landmark case, and no discussion of this topic would be complete without at least a mention of it. Now, the facts are no doubt well known. Mr. Maharaj was committed to prison for 7 days for contempt of court on the order of a High Court judge. Now, the judge didn't make plain to Mr. Maharaj why he was committing him, what the nature of the contempt was. And Mr. Maharaj duly claimed redress for contravention of his right not to be deprived of his liberty save by due process of the law. By the time the case reached the higher courts, Mr. Maharaj had served his 7 days and had been released, so the contravention was in the past. Now, before the Privy Council, by majority, it was found that there had been a contravention of Mr. Maharaj's constitutional rights. But what was the nature of the redress to which he was entitled, bearing in mind the contravention was in the past? It was argued on behalf of the Attorney General that the right to redress didn't include compensation, and that was because payment of compensation didn't amount to the enforcement of rights within the meaning of what was then Section 6. the PC disagreed. It was held by Lord Diplock that the order for payment of compensation was clearly a form of redress which a person was entitled to claim when a right protected under the Constitution had been contravened. And in a case such as this, where the contravention was in the past, this may well be the only practicable form of redress. Now, the case is not only important for establishing that compensation is available as a right, as a form of redress in constitutional claims, but Lord Diplock also made some observations about the nature of the claim. He observed that it was not a claim for damages in tort, but a claim in public law for compensation. It would include, in this case, loss of earnings consequent on Mr. Marriage's imprisonment and recompense for the inconvenience and distress suffered. Now, as I say, Maharaj was undoubtedly a landmark case. However, it did leave unanswered many questions. Now, we've heard from Tom the value of dissenting judgments, and Lord Helsham, in his dissenting speech, anticipated some of the questions that the courts have since had to grapple with. He said, and I paraphrase, "We are told this is not an action of tort, but if it's not a tort, but something sui generis, on what principles are damages to be assessed? Are punitive damages available? And if not, why not? How far may aggravated damages be awarded? And finally, are damages to include a sum for injured feelings or damage to reputation?" Now, Lord Hailsham, I would suggest, hit the nail on the head to this extent. It's clear, if one looks at the case law since Maharaj, that courts, whilst acknowledging that this is a distinct cause of action and that tort cannot be an exact analogy, have struggled to distance themselves completely from the language and principles of private law. Now, the question whether exemplary damages or punitive damages may be awarded by way of redress for contravention of constitutional rights was considered by the Privy Council in the well-known case of Ramanup, which was also an appeal from Trinidad. Now, the significance of Ramanup goes beyond the narrow point which was an issue in that case, which, as I said, was whether or not exemplary damages were available in constitutional claims. It also gave the board an opportunity to consider the function of constitutional damages. Lord Nichols, in a speech which has been recited in almost every case since on constitutional damages, held that when exercising its constitutional jurisdiction, the court is concerned to uphold or vindicate the constitutional right which has been contravened. So how might constitutional rights be vindicated? Well, Lord Nichols held that if the person has suffered damage, the court may award him compensation. Now, this is a concept which common lawyers will be familiar with. It recognises that the breach of an individual's rights may cause a person loss which should be remedied. This loss may well be pecuniary or it may be non-pecuniary. But Lord Nichols went on. He said that an award of compensation will go some distance towards vindicating the infringed constitutional right, but it may well not suffice. An additional award, not necessarily of substantial size, may be needed to reflect the sense of public outrage, to emphasise the importance of the constitutional right and the gravity of the breach, and to deter further breaches. Now, this second limb, the additional award, is an acknowledgement that the enforcement of constitutional rights is something in which the public, and not just the individual, has a stake. What Ramanup clearly establishes, and which has been a principle that's been restated in a number of cases since, and not just cases from Trinidad, but, for example, the case of Merson, which was from the Bahamas, that the overall purpose of constitutional damages is vindication. It's not to punish the state. And this is why, perhaps, constitutional damages, and in particular the additional award, has come to be known as vindicatory damages. Now, in Ramanup and in other cases which involve misbehaviour by the police, there is typically often not an issue about whether or not the applicant is entitled to damages. The question is normally how much and what time how much are they entitled to, and what type of damages are they entitled to. The facts in a case called James and Attorney General were rather different. In that case, a police officer complained of the failure to grant him an exemption from the language component of the qualifying examination for promotion to the ranks of corporal and sergeant. Now, although he was not entitled to an exemption, other officers in his position had received exemptions, and so he claimed that he had been discriminated against and unfairly treated contrary to the Constitution. The issue that arose in that case, and I would suggest this is again a throwback to private law principles, was must the claimant prove that he suffered damage as a result of a breach before he can have access to the court's discretionary power? In the board's view, there was no requirement that damage beyond having been a victim of a breach of constitutional rights had to be shown before compensation for the breach of the right could be considered. Having said that, entitlement to compensation was not automatic, where a violation of a constitutional right had occurred. That, of course, would undermine the discretion that had been invested in the court by Section 14. So the fact that Mr. James had been a victim of discrimination did not bring with it an automatic entitlement to compensation. The board suggested that where there had been no major impact on the claimant, a declaration was more likely than not to suffice. And the board, on the facts of this case, concluded that there was no acceptable evidence that the appellant had suffered injury to his feelings or particular distress. Despite having been denied the exemption, he had in fact been promoted, and he had continued in the rank of acting sergeant. As to the additional award, the Court of Appeal had considered, and I would suggest entirely sensibly, that theoretically an additional award might be made even if no compensatory award had been made. The board, however, preferred to reserve its opinion until a suitable case arose. This, in the board's view, was plainly a case in which an additional award was not appropriate. Now, the most recent case on the issue of constitutional damages, at least from the Privy Council, is a case called Lane and Attorney General. Now, this case, in a sense, also concerns proof of loss. It was a claim by and again, it was an appeal from Trinidad. It was a claim by the municipal police officers whose complaint was that they had been treated less favourably than regular police officers, including the failure to enact regulations which, among other things, would have provided them with a mechanism for resolving pay disputes, and that would have included a scheme of consultation and dispute resolution. Regular police officers had the benefit of such a scheme, they did not. Now, the Court of Appeal, having accepted that there had been a violation of their constitutional rights and that they were denied such procedural provisions as they were entitled to, didn't consider it appropriate to award compensation because it was thought that an attempt at an assessment of compensation would be an exercise in speculation, and it would be difficult to compute because no one could predict what the outcome of a pay dispute would be. The Court of Appeal also refused to make an additional award since the failure to enact legislation was not so much a question of willful neglect in the Court of Appeal's view as one of administrative sloth or inertia. Now, I would respectfully say that the decision of the Privy Council in this case is not as clear as it might be. The board held that while an award under Section 14 need not necessarily amount to the full financial loss which the injured party may have suffered, conversely, in some cases, it is right that an award should go beyond the amount of pecuniary damage which the injured party may be able to prove. Indeed, the fact that it may be very difficult for the complainant to prove a loss measurable in strictly financial terms in a case where there has been a serious violation of his constitutional rights may be a good reason for adding an amount to mark the importance of respect for the constitutional right which he has been denied. Such an award has attracted the label vindicatory, and I'm reading here from the judgment, although any award is in a real sense intended to be vindicatory, but it has the character of a general award. Now, general award, according to the board, provided tangible recognition of the value and the importance of the complainant's constitutional rights and vexation caused by their denial, albeit incapable of measurement in financial terms. In this case, an award of damages was appropriate. There was cogent evidence that the municipal officers' inability to present their case on paying conditions to an independent adjudicator was likely to have caused them loss. Denial of their rights were long-standing. The fact that there were speculative factors was, in the board's view, not a good reason for denying the assessment. Now, the reason why I say that the decision is not as clear as it might be is because it appears to me that it blurs the boundary between the distinction that was made, whether intentionally or not, in Ramanuk between the compensatory award and the additional award, what's now been styled as the general award. And I doubt that this is the last we've heard on the issue. At the very least, what it does is appear to suggest that even in a case where a complainant can't prove financial loss, they may still, in an appropriate case, be entitled to an additional award. Now, it's been over 35 years since the case of Maharaj, and we can see that the jurisprudence in this area is still developing. I'm now going to pass over to Rowan, who's going to consider the influence this jurisprudence has had in other Commonwealth jurisdictions and how they've dealt with the various issues that the Privy Council and local courts have had to grapple with.
Well, Hafsa is of course right that many of the most important cases in this area do stem from Trinidad and Tobago. I might suggest that there could be something of a correlation between that and the presence of a certain Mr. Ramesh Maharaj, who appears to have something to do with the majority of those cases. But it is, of course, a very important addition to the case law, and it has had influence in other areas in the Commonwealth, including in particular Canada and New Zealand. I'll take you to those cases in a moment. Very interesting, of course, to hear from Thomas Rowe and his interesting talk on dissenting judgments. It was, of course, the dissenting judgment in the case of Ramesh Maharaj in the 1970s that was eventually upheld as being the correct approach by the Privy Council. I only wish I'd been advised earlier in my career, perhaps at university, that all I need to do is to read the dissent in the case to fully understand an area of law. I might have saved myself a few hours of time, but there we are. Those of you that are still studying can take that on board. And there's three main areas in which I say the Caribbean case law has influenced the common law, the development of the common law. I'm only going to flag them up in relatively brief terms because it's been a long day, and if it was 65% for Mr. Rowe, probably somewhere dropping somewhere below that for me. But the headline, are as follows. First of all, I say that the Caribbean case law on constitutional damages has assisted in understanding in other parts of the Commonwealth what is meant by constitutional redress, and that such redress must include, in appropriate cases, an award of damages. First of all, the obvious point that the case of Ramanuk and those cases that have followed have been applied across the Caribbean in other jurisdictions with similarly worded constitutions. In Blomquist, Commonwealth of Dominica, a case called Innis, St. Kitts and Nevis, and Takituta, the Bahamas, and much more recently in a case called W in the Attorney General of Antigua and Barbuda in 2013. But that case law is not just about legislative interpretation and the meaning of redress under a constitution. It's about an underlying and important point of principle, and that is that there must be full and sufficient available redress under a constitution in order to give full effect to the rights contained therein. It is, I say, about the development of a modern conception of the rule of law. An example of this can be seen in a case called Gary and the Attorney General. That's a case from Grenada, 2001. The appellant sought to enforce an order that was requiring the Minister of Finance, the rice smile goes out to Mr. Maharaj at this point, requiring the Minister of Finance to pay the balance of compensation due in respect of lands confiscated by the state. It was contended that the court could not enforce the order against the Crown. The board went up the Privy Council. The board rejected that analysis. It held, by reference to the case of Maharaj, number 2, as follows, per Lord Bingham, to deny the appellant on the present facts the remedy he now seeks to enforce his constitutional rights would run counter to the board's constitutional decision-making, exemplified by Maharaj and later another case called Observer Publications. It would also run counter to the trend of constitutional decision-making elsewhere. It refers there to a case from Canada. The Crown was held to be subject to the provisions of the Constitution in the same ways as any other individual. The right to claim damages for constitutional violations is part of a package of measures, essential, I say, for the effective protection and enforcement of constitutional rights. More recently, there's the decision of the Supreme Court of New Zealand in Mervyn Chapman and the Attorney General. In that case, the Court of Appeal, in accordance with its then practice in criminal appeals, refused the claimant, or refused the appellant, I should say, legal aid. He was intending to appeal against his convictions for, amongst other things, sexual violation. Well, I didn't say of what, but that's all the report said. But at that time, the Court of Appeal refused legal aid and then dismissed the appeal on an ex parte basis, which was held, perhaps unsurprisingly, by the Supreme Court to constitute a breach of the right to fair trial under the Constitution. Now, the Attorney General run the argument there that your courts disposed of some 20 years previously, namely that constitutional damages could not be sought other than as against the Crown for its servants, in other words, not against the breach of the Constitution by the judiciary. Well, the board referred to the case of Maharaj, number 2, and noted that the Privy Council in that case granted a direct remedy by way of damages for judicial breach of constitutional rights of due process. The judge continued, speaking for the unanimous court, "I would continue to apply the principle in New Zealand because I think the approach is consistent with the obligations imposed under the New Zealand Bill of Rights Act and is supported by international and comparative case law." So that's the first thing I think we can take from the Caribbean case law and its influence as far out as New Zealand. The second contribution is this notion that I think Hafsa touched on, that constitutional damages are a standalone public law remedy and that it's aimed at the vindication of rights. That important notion has assisted other countries in getting to grips with claims made for damages under even very differently worded constitutions. But similarly to Tobago, in case with constitutions that do not expressly say you can claim for damages, it simply says under the South African constitution at that time, the court has power to grant appropriate relief. In a case called Foes and the Minister of Safety and Security in 1997, reference was made to the Caribbean case law in this area, and it was held that that included and must include, to uphold this principle of effective redress under the Constitution, to a right to claim damages in an appropriate case, and highlighted once again that it's a constitutional right, a public law remedy for a public law wrong. The next case is a Supreme Court of Canada case from 2010 called Allen Cameron Ward against the City of Vancouver. This is a case which, in which the police had received information that the claimant had intended to throw a pie at the Prime Minister at some sort of ceremony. I can't tell you what sort of pie. It seems to me it could be a material consideration. I mean, different pies might cause different types of damage, but anyway, I don't know any more information on the pie. Perhaps I should have googled that. But anyway, whatever type of pie it was, the police took the potential pie throwing incident incredibly seriously, and rounded up the pie-wielding attendee of the ceremony and strip searched him and left him in a cell and impounded his car, only to realise, in fact, he wasn't the pie-wielding attendee of the ceremony, who apparently didn't face justice. Anyway, perhaps unsurprisingly, the actions of the police were held to be a breach of the Constitution. Again, the Supreme Court of Canada made reference to case law from this part of the world and drew from that properly that constitutional damages are there to vindicate the rights of the individual, the court said that vindication included in the sense of affirming constitutional values. That is because, quote, violations of constitutionally protected rights harm not only their particular victims, but society as a whole. This is because they impair public confidence and diminish public faith in the efficacy of the constitutional system. Particular reference was had again to Ramanujan and the acceptable aim of the award of constitutional damages, including, in an appropriate case, whilst not being punitive, deterrence. I mentioned just very briefly the Supreme Court case of New Zealand, if I haven't already, called Mervyn Chapman. It'll be on my note that I post on the website afterwards rather than going all the way through it, but similar conclusions are reached. So again, we can see the Caribbean case law in this area is having a very significant impact and effect both on the argumentation before the courts and the final decisions arrived at. The last category of cases I want to touch upon, in respect of which the Caribbean case law has had an impact, is actually the development of the private law, of damages in private law. In Ashley and the Chief Constable of Sussex 2008, the claimants, this is a House of Lords decision 2008, the claimants were the son and father of a man shot dead by the police during an armed raid on his home. The family brought an action against the police in negligence for damages, but the Chief Constable very sensibly conceded liability for negligence and agreed to pay basically whatever damages they fancied. But undeterred by this, the family wanted to continue with their claim, and the issue that went all the way up to their lordships in the House of Lords was whether there was any purpose to continuing with the claim in circumstances where, in a private course of action, notwithstanding it being against a state body, in a private course of action, you've got your damages. What's the point? Well, Lord Scott said the point is, by reference, interestingly, to Ramanujan and the Caribbean case law, vindication. And by majority, they were allowed to proceed with their claims on the basis that part of the award of damages and part of the finding of a court is actually about vindicating your individual rights. So you can see here quite heavy cross-pollination between public law, private law, and the jurisprudence of this part of the world on constitutional damages. So it's having quite an interesting impact across a wide range. The very last case, just to add something into the mix, is a case called Lumber, the Crown on the application of Lumber, UK Supreme Court case again in 2011. Claimants claimed damages for unlawful detention pending deportation. The Secretary of State effectively applied a hidden policy on the detention of unlawful migrants. But it was held in that case that even if she'd applied the correct published policy, they still would have remained in prison. So the question was, or not in prison, in detention, but the question was, well, again, what's the point? There's no damages. Well, up to the Supreme Court on one point, which was, well, should they get vindicatory damages? You're not going to get damages other than nominal damages for false imprisonment because you'd have stayed in prison anyway, but can you get vindicatory damages? Well, reference was made to Ashley in the House of Lords decision in that case, but Lord Dyson was rather less keen on this than Lord Scott, and had the following to say: the implications of awarding vindicatory damages in the present case would be far-reaching. Undesirable uncertainty would result. If they are awarded here, then they could in principle be awarded in any case involving a battery or false imprisonment by an arm of the state. Indeed, said Lord Dyson, why limit it to such torts? And why limit it to torts committed by the state? I see no justification for letting such an unruly horse loose on our law. Well, what we can see from this, I think, as Hafsa indicated by reference to Alain, it's still very much an ongoing process. There's a dialogue. Much of that dialogue is being contributed to significantly and helpfully by jurisprudence from this part of the world. Let's hope that this continues and the exchanges like this continues and it keeps developing. Thank you very much.
And Rowan, thank you very much, particularly for the clarity of the presentations. I'm predicting that those are papers that people will want to read when we publish the proceedings from the program. It's certainly being reminded of the influence that jurisprudence from this region has had on the rest of the common law jurisdictions is impressive. It makes me think that perhaps we should revisit that question that was asked in Buchanan a couple hundred years ago about whether Cayman can pass a rule that should bind the rest of the world. I'm going to invite Richard Samuel to join me on the stage, another colleague from Three Hair Court. Richard has a wide-ranging practice, commercial practice, and with me, a particular interest in financial market cases and the relevance of arbitration, mediation, and more generally advocacy to those cases. He's respected for his advocacy skills and, not surprisingly, therefore, much in demand as an advocacy trainer as well as an advocate. Now, Richard and I, we're just guessing, but it's a bit of an educated guess based on what we've been reading in the local press over the last couple of days, but we're just guessing that there might be heightened interest in this audience in international finance at the moment, on the way monies move around the international financial system. There is actually certainly heightened interest in London, where we packed our bags, in that question, in no small part because we have a case unfolding in front of us at the moment about benchmark manipulation, about LIBOR rigging in the markets. And I promise you, it's the tip of an iceberg. We're going to see that litigation run and run and run, and we're going to learn a lot that we may, until now, perhaps only could have guessed at. In the interest of time, I'm going to jettison a longer paper, and I'm really going to just try to make an observation, float a theory, reference a couple of things that, as we've thought about this, just don't make sense to us, and I want to get your reaction to that if we can. But also, in light of that, we want to throw out a few ideas about what some of us, and we need help for this, are trying to do to move us to a better place. We do all of this against the backdrop of the global financial crisis. And the observation that I want to make is that if you read your newspapers, as I was just alluding to, if you read your newspapers, they're full of discussions about reform of the regulatory scheme of things, better financial market regulation, as a way of dealing with a number of the disappointments we've lived through as a result of that global financial crisis. So regulatory reform, though, regulation, to my mind at least, is more in the nature of preventive medicine. Now, preventive medicine is important. It's important in our personal lives just as it is in the lives of our financial markets. But it's preventive medicine. And by analogy, the courts, judges, arbitrators, if that's where we go with our issues, they're our hospitals. And my observation is we just haven't seen anything like the coverage, the interest in reform and what we could do better to support our courts, our judges, to improve dispute settlement in this arena. Everything is looking at preventive medicine. That gives rise to a theory that I have, which makes that observation rather troublesome. And my theory is this, that judges who understand finance can be a huge ally of the regulators in mitigating global financial systemic risk. Judges who understand finance can do a great deal. In fact, when I was a young lawyer, I read the law and tried to keep abreast of the regulations, but I studied the cases. That's our common law tradition. That's where I got my roadmaps. The regulation is being rushed through. It's going to have to apply to a very dynamic marketplace. And judges who understood things could move us along that path as we needed to. But the corollary of my theory is that judges who don't understand finance are themselves a potential source of systemic risk. And that's particularly true in the modern scheme of things, where the markets trade frequently off of standard terms, standard contracts. a standard form contract that I had the challenge of holding the pen and writing when no one thought the business was very important and now supports $600 trillion of trading, they tell me. I hope we got it right. But in any event, if a judge makes a mistake interpreting one of those terms, that mistake goes around the globe, infecting, contaminating trades far removed. It's given rise to a phenomenon that very often parties outside of a dispute may have at least as great an interest in the outcome of that dispute as the parties who are litigating it. And they may not spot the issue. They may have strategic reasons for ducking an issue. They may not have the resource to really develop it. Very interestingly, we've just closed a consultation period in London on a roles-building initiative, an initiative of the High Court and the Chancery Court, and they are proposing issuing advisory opinions in light of wider market interest in financial market cases, along with identifying specialist judges, expedited procedures, and other reforms. So that's my theory, if you like. And there's a lot at stake. It's complicated. It's very global, very international. No, these trades don't respect national boundaries. And it's troublesome, therefore, that historically our contracts have, without thinking about it, sent parties, wherever they may be located, to the same one or two courts for their dispute settlement procedures. Now, that may have made sense when it was a more homogeneous, localized, high-credit marketplace. It makes less sense as the game spreads geographically as it has done, and as the matters at stake become as great as they are. It makes no sense, therefore, to put people on airplanes from some remote part of the world and say, you must go to England, you must go to New York, and maybe have to convince a jury who would struggle to place your jurisdiction on a global map, to convince them of your case. It particularly makes no sense when you're doing that in a language which is not native to the parties, when you're doing that in a way that will bring, the most you can hope for is a judgment which may prove difficult, if not impossible, to enforce where it needs to be. That makes no sense. But at largest measure, that's what the game continues to be. Similarly, it makes no sense to send the parties to a local court where they can get a binding decision if the judges deciding those cases don't have the requisite experience, competence in a very specialized matter. That makes no sense either. My experience from the financial markets to date is that markets want certainty, but they'd rather have an unenforceable right decision than an enforceable wrong decision. And similarly, even in courts where there is, collectively speaking, considerable experience, it makes no sense to take the roll of the dice and hope that the judge that hears your case falls in that category of experienced judges. That makes no sense if we have a standing group of experienced judges, lawyers, marketeers who are standing ready to step in and provide that kind of specialized and expert determination. It makes no sense that we have special subject matter courts for everything from family law, juvenile crime, IP, bankruptcy, etc., but not for finance. World trade, the WTO has its own tribunal. Is world trade more, I don't know, global, more complicated, more systemically relevant than finance? I don't think so, but that's where we start from. It certainly makes no sense, with all that's at stake, to put all of our eggs in the single basket of better regulation. That makes no sense at all. So I'm going to turn to Richard, because we've been thinking about how we move on from this, and things that might make a difference. And as you'll hear, it's something that is not local to London. It's something that we're here partly to recruit and to, in a sense, hopefully excite people here to joining in the collaboration of getting us to a more logical place. Richard?
Well, it behoves me to be brief. I'm going to say a few words about the consequences of moving away from traditional forms of dispute resolution towards alternative ones, like arbitration. Nowadays, financial services disputes may not be a large part of your practice, or the practice that you might be expecting to start as a student. because the banks are, your clients here are entering into agreements with banks on their terms, and those terms will choose New York or London as choice of law and choice of jurisdiction. So you would be handing those cases on to lawyers in those jurisdictions to deal with. So at the moment, it's not going to be a great part of your practice. But in the arbitration future that Jeff is talking about, then there's an obvious role for you. And the obvious role is to assist in the conduct of an arbitration if it's here in Trinidad. Obvious also is your opportunity to help enforce the award. But less obvious is that wherever the arbitration is going on, if your client is here, as the matter is being arbitrated rather than litigated, you can continue to have a role in that case and collaborate with co-counsel around the world so that you can work together, as you do with counsel in the Privy Council, for example, to fight the case for your client. So in the future, as we move towards arbitral resolution of these disputes, it will be part of your practice, we hope. So to make it part of your practice, you're going to need the right relationships with the right lawyers in New York and London to help you fight those banks. So what is it about the global financial crisis which is moving us in this direction? And what do you need to know if you're going to be fighting any of these financial services disputes? Well, the sentiment from after 2008 is that the system is rigged in favor of the banks because they'd been preaching the virtues of market discipline as an engine for economic growth. And they'd been visiting that market discipline on their own clients when they ran into headwinds and they were foreclosed upon. But when the winds, the cold winds of market forces blew against the banks, they were able to avoid those consequences. And it was the taxpayers who bailed them out. And so there's a sense in the markets, or in the political sense now which has developed, that there is an account which is yet to be settled in favor of the taxpayer at the expense of the banks. And so we have a global move towards heavy regulation from the kind of light regulation that we used to have pre-2008. So what does that mean for you as a lawyer? Well, when you're considering a case for a commercial client here, for example, with a hedging product against a loan that it may have, the obvious common law claims that you will be familiar with are misrepresentation of fact and negligent advice if the bank moved into the area of giving advice as opposed to giving no advice at all. That's what you'll be familiar with, of course, from your general commercial practices anyway. But since 2008, things have been moving rapidly in the regulatory sphere. And in London, for example, we've moved from the Financial Services Authority to the Financial Conduct Authority. And they have produced something called the Handbook, which sets out a whole series of statutory rights which are really rather involved and rather complicated. In fact, it's a bit of a misnomer because you can't even hold the book in your hand. You can't even print it out because it's so big. This is a large and rapidly developing area of the law. There's only one case I want to talk about, and that's the case of Rowley and Green versus the Royal Bank of Scotland. And this is a case from 2013 in the Court of Appeal in which there was, the issue in the case was whether these new statutory rights are coextensive with the common law. Is the common law following these statutory rights? Here's an example of one of the statutory rights to give you an idea of the kind of thing that we're talking about. I don't think they're drafted by titans of the common law, rather more by civil servants. COB 5.4.2G, Principle 7, brackets, communication with clients, close brackets, requires a firm to pay due regard to the information needs of its clients and communicate information to them in a way that is clear, fair, and not misleading. Now, if that didn't reach its own high standard, it then goes on to explain the purpose of this section is to ensure that the firm takes reasonable steps to ensure that a private customer understands the nature of the risks inherent in certain transactions. So, if you cut through that, you can see that the judiciary, as these are now private law rights for certain kinds of customers, are having to cut through that kind of language to distill what rights your clients will have as against banks. And you can see, I hope, through that language, that we're moving from a situation in which the bank chooses whether it wishes or not to advise, to whether it is obliged to give sufficient information to its clients, so it is forced to give the advice to allow the client to make an informed choice. So that's the kind of stuff that you're going to need to know about. But the difficulty is that there's an awful lot of it, it's changing very rapidly, and the jurisprudence around it is only just beginning. So, as I say, the important thing is the right relationships with people in London to help, or in New York, to help you understand the latest regulatory changes which are giving additional private law rights to your clients which you're not necessarily going to be familiar with. So there we are, that's all I wish to say. I'm going to hand back now to Jeff. Thank you.
Thank you, Richard. By the way, it's not going to go away. If I ever thought that I was operating in a niche area, I'm constantly being reminded, if you drive into London on the M4 motorway between Heathrow and London, there's a big billboard. And remember, this is advertising to motorists and truck drivers. And it says, have you been missold a swap? If you have, call 0800, and there's a number. This is a different world that I think we're looking out at from the world we look back on. Well, we're again trying to save some time. I'm about to make myself the least popular person in the room. It's been suggested that we forego our coffee break. Anybody who needs a comfort break, please, by all means, take it, because it's going to take us a little while to get the next group, which is a panel, up on the stage. We're going to keep that as tight and as short as we can in order to get you also out on time. But we are trying to catch up a little bit, and Ronnie, is that the right decision, you think, for us to make? So, sorry, don't shoot the messenger. But I'd ask Simon Davenport, Queen's Counsel, to join me on the stage and convene his panel. As he's doing that, I'll just say a word about Simon, and I'll let him introduce his very distinguished panelists. Simon, I've been talking about rising stars in the three-hair court. Simon's an established star in three-hair court. He practices in the areas of, in particular, and it's again wide practice that Simon has, but in particular in the areas of civil fraud, commercial dispute resolution, insolvency, and, as we've just been discussing, arbitration cases. But he heads our chambers groups in all those areas. So Simon, please, over to you. And, you know, somebody very clever once said, you're only as good as the company you keep. Simon's going to be keeping some pretty good company, so you'll see a big grin on his face, I promise you. Thank you.
Jeff, thank you very much indeed. Right, what I'm going to try and do is two things, capturing your attention. The first is to ask my panel members, please, to come up onto the dais here and get hooked up, because I think you're going to have to do that. And the second thing is just to make a couple of introductory remarks, still holding on to your attention. I've been reliably informed that it's not just you I'm talking to, but in the entire population of Trinidad and Tobago, who are listening in as we speak on various radio stations. So it's not just hello to you, but hello to them, good afternoon to them. And they don't have the conference packs, so they don't have the CVs, and I'm going to in due course just introduce a number of the members of the panel to them and of course to you. However, seriously, we at Three Hare Court Chambers, I remind you, in the Temple in the City of London, are absolutely delighted to be here today and to be in your fantastic country, which has wealth, strength, and if it's handled well and in the public and not necessarily merely the private interests, and if it's handled with moral self-discipline, has an amazing commercial future. We're very happy to contribute to the inaugural Trinidad and Tobago Legal Network. And we congratulate your leading lawyers on putting this network together. which, through its insistence on rigorous, open, fearless support for proper democratic and constitutional process, honours and decorates your country. Now, on the panel here, now assembled, we have an array of talent from lawyers in London and also in Trinidad. I'm just going to introduce a few of them to you, listening at home and also listening here. And we have Fayed Hussain, Senior Counsel, a most distinguished leading attorney and senior counsel of this country, topically in the limelight. I fear that the world will soon be hearing a lot about Mr. Hussain, not just in the country of TNT and in the Commonwealth. He has, of course, like a number of the senior lawyers in this country, itself not an uninteresting event, had important roles in the world of academics, political life, and corporate and economic activity. Next, I'd like to introduce Mr. Raj Kumar, Mr. Ravi Raj Kumar, hugely experienced and excellent attorney in principally, but not only, serious criminal law cases. And anybody practicing in the Privy Council will be well familiar with his name from all the many cases that he's been involved in, which have got there. Lastly, on behalf of the TNT team, I'd like to introduce Mrs. Persad Salik, highly experienced attorney, I think some 21 years in practice, and importantly an academic, and with long association with the Hugh Wooding School. Over to the London team wearing the red shirts, we've got James Guthrie, Queen's Counsel. Now, you've already had him introduced to you, so I'll keep it short and snappy. But make no mistake, he's one of the greatest British Privy Council lawyers there's been. He's immensely experienced across the entirety of the Caribbean and often appears there at various different jurisdictional stages. He's an administrative and public lawyer, and he has the added advantage of sitting as a deputy judge in criminal cases in the United Kingdom. And he's formerly, for many years, our head of chambers. Next we have Professor Satvinder Jus, and you've actually heard from him already. He is a distinguished law professor in King's College, London. He's a practicing barrister at the same time. And an attorney, as you might say, in judicial review administrative law. I had the privilege of leading him recently in an important Chancery Division case, determining whether the English Supreme Court could even hear a live appeal between warring religious factions about the justiciability of religious issues in English courts, and indeed the common law world. And lastly, by no means least, Tom Poole at the end there, who is a member of the A-list panel of Treasury work, doing the best and the most difficult government work. Both a judicial review lawyer and also a commercial lawyer. He and I have just finished one of the largest civil fraud cases to have happened in recent years, and I can attest to his brilliance. So, first of all, we're going to go to the questions, and I'd like to say thank you very much indeed for those of you who have given us a lot of questions. We're not going to be able to take them all, but we're certainly going to be able to take some of them, and thank you for everybody for making your contribution. So the first one I've got, and I'd like to choose Fayed for this one, please. Do the present arrangements regarding extradition proceedings, including the legislation, adequately protect an accused person? I think we can add in Trinidad and Tobago. Unless I've got it wrong.
The Americans would call it a curveball. in the Commonwealth, we call it a googly and a Chinaman ball with a piece of it in swigger. We need to draw a line in the sand in this country between the procedure for extradition proceedings. Is that better? Pre-1986 and after 1986 and thereafter. What happened in the former legislative regime was that extradition proceedings were rooted in criminal law. So to have someone extradited, you had to provide the evidence that would ordinarily be provided if someone had to be committed to stand trial in the assizes. So therefore, there was no multiple hearsay evidence. There was no evidence from anonymous sources. There was no opinion evidence. There was some cross-examination. But the quality of evidence that had to be produced had to be first-hand evidence in some kind of declaration or witness statement or affidavit, as the case may be. And what the magistrate did is looked at that evidence and determined whether that evidence met the standard of a prima facie case that will warrant a committal ordinarily. What happened in 1986 and assumed momentum post 9/11, especially in the 2000 and thereafter, was the law, not only in this country, but a number of countries in the world underwent very fundamental changes in respect of extradition. What it did is brought into play something called the record of case procedure. And two things happened. The world was divided, first of all, into Commonwealth countries and non-Commonwealth countries. In respect of Commonwealth countries, you had extradition on the basis of this record of case, but the evidence that had to be satisfied is evidence that was produced in a record of case, so there were no witness statements. There was no requirement for multiple hearsay, against multiple hearsay. Evidence could be obtained which was totally hearsay from anonymous sources, as the case may be, opinion evidence. And that was the basis of a committal with no cross-examination and a summary of the evidence rather than the evidence itself. So that placed the accused in a very difficult position. But it's even worse in respect of a non-Commonwealth country. Because in respect of a non-Commonwealth country, the executive could agree to a treaty with the non-Commonwealth countries that made the evidential threshold even more bare. And therefore, they could qualitatively reduce even the meager provisions that existed with respect to Commonwealth countries. So I want to draw an example. Suppose, for example, there's this island in the Pacific called X, and there's this island in the Atlantic called Y, and therefore someone in Trinidad is accused, or there's an extradition request in respect of him, in respect of something done in the island in the Pacific called X. What happened in X was that someone might have sent some money through Y to be paid to Trinidad, and Y in the Atlantic decides that it was going to pass a law that had extraterritorial effect through the entire world. In other words, it legislated extraterritorially, notwithstanding the fact that the accused never visited country Y in the Pacific. He can be extradited, and he can be extradited on the barest of minimum of evidence. What we have now is that the rules in respect of someone who is accused is much more onerous, so there is no equality of arms. Whereas the requested state can do so on a record of case which is certified by a prosecuting authority or even less. The accused person has to satisfy the requirement of reliability. He's now subjected to be extradited on the following criteria. First of all, opinion evidence. Secondly, multiple hearsay. Thirdly, no witness statements. Certification by a prosecuting authority from the requesting state. And therefore, the process of extradition is reduced to perhaps half a day and a couple of hours in the magistrate's court, with no access at all to who has made those allegations, who are the anonymous witnesses, no cross-examination as the case may be. And the whole dynamic has changed. Now, that has to be looked at in the context of what prevailed before. And it also has to be looked at in the context of the fact that extradition law is extremely draconian. You're taken away from your home, you're deprived of freedom of movement, you're deprived of your family life, you're deprived of access to your loved ones, you're deprived of access to a home environment, and you're now subjected to charges which may not have an exactly equivalent charge in the country in which you live, as the case may be. The point about it is that the states of the world, especially post 9/11, have got together and constructed laws in respect of extradition that has caused a lot of hardship and made a lot of, cut a lot of ground, a lot of rights away from the persons who have been extradited. There's one sign of hope, however, and that is that in this country, we are fortunate to have the Court of Appeal, Justice Kangaloo, Justice Jamada, and Justice Weeks delivered a very powerful judgment about 2 years ago in a case of Ferguson against others, which I appeared in which they indicated that if it is the charges were laid here, they would apply the forum argument in respect of extradition. That is, they will apply the argument that you can be heard, or apply the principle that you ought preferably to be heard and tried in the country in which the offences were committed.
Thank you for that.
That's the nutshell, is what is the position.
Yeah, and quite a big nutshell. And I have a feeling we're going to be hearing that stated over the next few weeks, months and years. But that is incredibly helpful, and it couldn't have been more topical to have heard that from Fayyad. So thank you very much, Fayyad, for that. But just before we leave that question, I'd like to ask Ravi whether or not you've got any comments on that, perhaps a different view?
Well, I don't think I have a different view. I think that the extradition procedures do, in fact, breach a lot of the fundamental rights. From the very beginning, it seems to be more of a rubber stamp than anything else. You have this record of a case that comes down here. There was the case of Peter Morgan, where all the evidence of Peter Morgan was by anonymous witness. And there was absolutely no redress at all for what was, I think, third-hand hearsay. It went to the High Court, and then because of the delays in the system, the client decided to terminate his long route through the courts and face the courts in America, just simply because it was taking too long. Again, a fundamental problem. The other difficulty you have is the almost automatic denial of bail in most extradition cases. You have a statute that says you can only deny bail for substantial causes, or where there is substantial evidence of a risk of flight or a risk of any of the three proceedings. But you come with an extradition proceedings and you're told extradition, the relationship between states is more important, therefore deny bail. And that fundamentally, I think, is a major problem.
Yeah, thank you for that. I think we've all got stories like that. I'm going to move on. I don't think anybody's brave enough from the English team to actually counter what's been said. If they are, they'll speak now. I think not. May I congratulate them on their wisdom of backing off on that. I'd like to move to another question, and I've got Mrs. Salick in mind to open the batting for this one. The citizens of Trinidad and Tobago, in the majority, are reluctant to make the CCJ the country's final appellate court. How do you view this? Thank you for that excellent question.
I'm curious to find out what kind of survey was conducted to gauge what is being said, that the citizens are reluctant. And we've been hearing a lot about the CCJ. In fact, it's been in the making for many, many years now. And the irony is that we have the seat of the court here in Trinidad and Tobago, but we've only signed on to the court in its original jurisdiction, not in the appellate jurisdiction. And to say that the citizens do not want the court, I think is I don't believe that there is any evidence to back that up. I think if you were to poll the citizens properly and the proper survey were to be done, we would find that yes, the citizens of Trinidad and Tobago, as many other citizens of the Caribbean region, are yearning for this court. We want this court. This ought to be our final appellate court. We have gone through many, many years calling for it, and it is a real mark of true independence to have the final court as the Caribbean Court of Justice. So I do not agree that the citizens are reluctant. In fact, I think they are more than willing to have it on board.
Okay, can I hear a different view across our panel? Yeah, Fayyad.
Well, then I will say bring on the referendum as the case may be. Absolutely, and let's prove it. But I want to make two short points. The first point is the notion in this country that somehow, if you have the Privy Council, it's a derogation from your sovereignty. And that's absolute nonsense. Because most of the countries in Europe have subscribed to international courts in Strasbourg and in Luxembourg, as the case may be. And it's not a derogation of their sovereignty. In fact, we, in this country here, initiated the International Criminal Court. Mr. Maraj was Attorney General, and it's not a derogation of our sovereignty. And that's my absolute position. And the second point I want to make is the issue of confidence. If we do not have the Privy Council and the wisdom of the Privy Council, the problem we have had in this country for the past 40, 50 years, as the case may be, and the quality of leadership and the quality of jurisprudence in respect to the Privy Council is unparalleled. And forgive me for making the third point, and it's the issue of any legal system has to be built on the basis of an international standard of all kinds of principles, whether separation of powers, whether rule of law, whether human rights, as the case may be. These are not subjective national standards, these are international standards.
Yeah.
And in the Privy Council, we get an opportunity to tap into a reservoir of high-quality jurisprudence that will otherwise be denied access to. And finally, I want to touch on the issue of interference with these courts, because do you know that the Chief Justice from the Court of Appeal of the other Caribbean islands was not appointed because one Prime Minister took objection to a judgment of his? And the problem that arises in all of these countries is the level of interference that is possible and the perception of interference in the judiciary. And we have to think about it very carefully. So I say bring on the referendum, let us have a debate, let us go forward, let us inform the population, and let us take a decision as to what has to
Thank you very much. I'm going to get tougher as a... I do want to have an English view on this, so I'm going to ask James Guthrie to express, should countries like Trinidad and Tobago be, as soon as they can, trying to get total independence and join something like the CCJ, or should they do it either slowly, or should they not do it at all?
Well, I believe that it's a question which must be decided within Trinidad and Tobago. The debate should be held here. I think the Judicial Committee will always be there if it is wished by the populace, if it is still useful, if it can help, if it can contribute to democracy, then it is more than prepared to do so. On a personal level, can I make a
small plea? Has this gone off? Can you hear me? Well, it's a small personal plea. I hope this debate will run and run for at least the next few years until I'm safely retired. Will not be, my practice will not have been removed from beneath my feet.
Thank you very much. Okay, we're going to move on because we've got a lot of questions. Next question, is the presumption of constitutionality still an applicable principle in determining the validity of legislation? And I'm going to ask Fayad to open for the home team on that one.
This principle is a principle that arose out of the presumption of validity of normal commercial documents, and was transferred on to the presumption of constitutionality in respect of legislation where it does not belong. At the very least, it is occupying a neutral position. There should be no principle of constitutionality. It should be neutral. It was developed in a country in which parliament is sovereign. And therefore, the will of the people found expression in legislation, and therefore a sovereign parliament had to be respected. In this country, the constitution is sovereign. And therefore, you cannot apply that principle to our legislation, notwithstanding what Lady Justice Hale said in Surat, and what was said in Grant and all of those cases. So therefore, that principle should go. The judiciary should not be fettered with this issue of presumption of constitutionality. It should be allowed to do its work. It should not be differential to the legislature. It must have the full ability to reduce legislation, to declare it null and void without the encumbrance of the principle of constitutionality. I don't want to talk too much because I want to share the time.
That's fine. I'm going to move on to others soon, but I'd just like to end this because this is with the TNT chapter of this talk particularly, before I open it all up a bit more globally. I'd like just one of the two, Mrs. Salik, do you have a view about this?
Yes, I wanted to say that with respect to the presumption of constitutionality, and we're talking about primary legislation in particular, but I think the next wave of litigation is really going to come with subsidiary legislation or delegated legislation and this whole presumption of constitutionality. Within the past, recent past, I should say, we've had two quick prorogation of parliaments, and Mr. Marachi would know about that. And in that period, especially with subsidiary legislation, we have a procedure, constitutional procedure to follow. And I dare say that I'm not quite sure that that procedure was always followed. So to respect to Section 53 of the Constitution, Parliament may make laws for the peace, order, and good governance. I don't know that there has always been true adherence to that, and there may have been breach of that Section 53 with respect particularly to subsidiary legislation. So that presumption really can be rebutted.
Thank you very much indeed. Ravi, anything on this?
Perhaps I could just home in on the criminal side of it. The Bail Act, there was a recent amendment to the Bail Act in this jurisdiction to allow for the detention of persons charged with certain firearm-related offences for 120 days. Now, to me, that is both unfair and unconstitutional. The difficulty you have is you have a forensic science centre who is not able to provide a certificate of analysis to say it is a gun or firearm within 3 years. So you're almost guaranteed that a person arrested is presumed guilty. He's going to go and spend at least 120 days in prison, knowing fully well that no trial can start within that time. Manifestly unfair.
Thank you. Could we pass the microphone down to the end? Because I'm now going to ask a question which I think applies both in the UK and also in TNT and lots of other jurisdictions as well, which is within the context of civil litigation about what was perceived as the two enemies of justice in the civil system, namely delay and costs. Now, my own personal view is that after the introduction of the civil procedure rules, the CPR, in England in 1999, that largely delay was tackled within modern civil legislation in litigation in the UK. I think the experience here might be slightly different, but I want to go to Tom Poole. Tom, what's happened recently? Are there any instances of us pushing the boundaries too much in our attempt to deal with either delay or costs?
Can everyone hear me without the microphone? Excellent. Well, I think there are two competing considerations. There's obviously the need for litigation to be conducted efficiently, and there's the need for cases to be dealt with justly and taking all circumstances into account. And it's quite common, and I'm sure all the practitioners in the room and all the students as well will have at least read or been involved in cases where a party in default has faced a significant uphill struggle, mainly due to lower courts' emphasis on the need for litigation to be conducted efficiently. And sometimes, in sort of my experience and other practitioners I'm sure here, their experience is it's gone that way too far. And in England and Wales, there's been a number of cases following some reforms to the civil procedure rules that removed the checklist for relief from sanctions under R3.9. And I understand, and I'd be interested to hear from the TNT representatives on the panel if the position is similar, because my understanding is in Trinidad and Tobago, it's a slightly more draconian approach to sort of procedural rules. So if you're in breach, then to a certain extent, that may be the end of the road for you. But certainly in England and Wales, there was a case that everyone's probably familiar with, Mitchell and News Group newspapers, that introduced a sort of three-stage test to a party in default. So take the classic example, you're late putting in witness statements. The three-stage test that would be applied under Mitchell was, first of all, was your non-compliance sort of trivial? And generally speaking, if it's trivial non-compliance, you're fine, you will get your relief from sanctions. If it is non-trivial, then the court would consider if you've shown sort of good reason for your non-compliance, stage two. If you have not shown good reason and it's a sort of non-trivial breach, you move to the third stage of the sort of three-stage test, and that is the very general catch-all. You look at all the circumstances. Now, there's nothing fundamentally wrong with Mitchell and all the cases that followed Mitchell. The problem was that the courts, and certainly the lower courts, were applying Mitchell far too narrowly and in a fairly draconian fashion. And that's why you had a spate of cases where you have an example, a party putting in a witness statement or filing with the court a witness statement 3 hours late. You were not allowed to rely on that. You had to make your relief from sanctions, and relief from sanctions application was not allowed in one case. What followed is a bit of a rowback from Mitchell in a case called Denton, which again even Trinidad and Tobago lawyers may be familiar with, it was a decision of the Court of Appeal, England and Wales, about 6 to 9 months ago. And what has happened as a result of Denton is it's a bit of a rowback from Mitchell. And now the courts have actually said in terms that parties that take sort of unmeritorious stances when it comes to short extensions of time will be penalised in costs. And so what you have, as I see it, is a situation where the courts have tried to interpret a change to the civil procedure rules which was designed to make cases more efficient and progress more efficiently. They've gone slightly too far the other way, and you're now having a bit of a rowback from that. And the cases certainly following Denton, you have situations where relief from sanctions is granted more readily than it was under Denton. So I think that's
the English Court of Appeal has decided to clarify in Denton. When it's got it embarrassingly wrong, it clarifies it in a subsequent decision. I don't know how you deal with the language here. But I'm in the Supreme Court on one of these cases in November, if that happens. And Richard Samuel, who you've heard from this afternoon, and I are in 2 weeks' time doing another one of them in the Court of Appeal, where after 50 minutes, we excluded, it was 50 minutes late, and we excluded the entirety of the evidence that the other side was going to rely upon, albeit because they were trying to introduce new documents and new arguments. So thanks, Tom, for that introduction. I would like to hear just from one TNT person about whether or not there is any experience of a like nature. So this is the expression, no good deed will go unpunished. This is the British courts doing their level best to not make, this is not new law, this is a judicial interpretation of what civil procedure rules should mean. And what is going to pass the test and what is not going to pass the test. So, TNT lawyers.
We'll defer on this issue. We want more interesting issues.
We've earned a fortune out of it, mate. I have to say, it's been a fantastic issue for us.
Quite a right first. In fact, 2 of the cases went to the Privy Council. I think that Peter appeared in them in respect of relief of sanctions and all of that, right? I think our law is draconian, but it's not pretty settled.
All right, okay, we'll move on. But in fact, I want to stay on the same topic, and let's stick with the TNT team. This is a difficult question, but it follows from delay, which is what mechanisms can you employ to get a judge to deliver his or her judgment when it's been outstanding for a long time? What is a long time in Trinidad and Tobago, and what can you do about it?
Ramesh and I have experience of more than 5 years in the Court of Appeal.
Oh dear.
Still not delivered. Court of Appeal. Now, you're caught in a conundrum. On the one hand, you want to write to the judge. On the other hand, you're concerned about subconscious bias, and I'm very, very frank about it. You're asked to satisfy very strict timelines in terms of witness statements, in terms of skeletal arguments. You're asked to leave your summer holidays, as in that case, and prepare for trial in September. And yet 5 or 6 years go by and you get no judgment, and it's very difficult. You're asked to deal with a situation where how do you handle that in the interest of the client and at the same time maintain as far as possible the dignity of the judiciary, as the case may be. So what do you do? It's a combination of persuasion, diplomatic savvy, and finesse. You have access to the Constitution, of course, under protection of the law. I think Luna did one many years ago from the Industrial Court. And fair trial rights are engaged as well because you're entitled to a judgment within a fairly short space of time, which of protection of the law provisions of the Constitution and fair trial rights.
Sure. So this is all the formalities.
This is what I will,
practical answers. What do you do? Your client phones you up. No. No. Your client phones you up and says, I've had enough of this, do something about it, and do it this afternoon. What are you going to do?
You write the judge, first of all, your solicitor will instruct him, then he writes the judge.
Okay.
You get the other side to write the judge, you both write the judge, you go to see the judge, and if it, write the Chief Justice, if it gets very rough, file an action.
File an action for what?
File an action for breach of constitutional rights in respect of fair trial rights and protection of the law rights, because I think that the protection of the law rights and the fair trial rights include a right to be given a judgment within a reasonable period of time. And secondly, there is a legitimate expectation because the judiciary has imposed on itself a 6 months time frame in terms of when it ought to deliver judgments, which they extend from time to time. Yeah. But they have been good by and large, but there are instances of judges leaving the bench, for example, who have judgments to me who have never delivered it. One retired prematurely and went off somewhere else, and It happens.
We had a case where Sir Jeremiah Harman, James might know this because I'm going to ask James for a comment in a minute. Sir Jeremiah Harman, I think he was 18 months deciding, or nearly deciding, the case. Unfortunately, lost the papers in the meantime, which is slightly problematic. What can be done in England, James?
Well, I think one would probably get a more sympathetic hearing from the Chief Justice if one wrote. But I don't know that it's an uncommon thing to have a very long delayed judgment. I did have one from Trinidad where the judgment was delayed for a very long time, and one of the appeal court judges died before it was delivered. And I'm afraid, just at the moment, I can't remember what happened.
Yeah, but let me pass it down the line. I mean, what can be done? You can't appeal something that hasn't been delivered. We don't have a constitution.
No. No, I mean,
take judicial review proceedings.
Well, yes. I mean, in position in England and Wales, we wouldn't be able to, as you say, Simon, file a sort of constitutional sort of motion, but there is scope for a judicial review claim. I mean, it's very rare, as James said, it's very rare, and I can't see that action would be taken sort of lightly, but you could. And it feeds into legitimate expectations to a certain extent.
And also it feeds very much into Sir Fenton's speech this morning, which of course is that you've got to have a top-down vigilance has been used by Sir Fenton and also James and other people today. You have to have leadership from the top, and the public has to put pressure on its leadership to act appropriately from the top. And you have to, in bringing that pressure, that is how you percolate it properly, so that the pressure comes on the judiciary. In England, this doesn't happen generally because they're pretty scared of consequences. They're constantly being overseen about their delivery on various different things. And I can tell you the answer on lateness to fired is in the UK, it's 3 months. James Dingman's now become a High Court judge. He waits 3 months for a judgment. That's without a very good reason, already very late, black mark. Perhaps in Tom Rowe's secret book of that never gets opened apart from the minister. Okay, well, thank you very much, everybody, for that. That's very helpful. I'd like to keep with the English team to start with, and I'd like Professor Satvinder just to answer this one. It's a direct question. Has the law of legitimate expectation gone too far?
If you don't mind, deal with the one you just dealt with.
Yeah, please.
The Harman case is a unique case because it was so troubling that, as I recall, the parties took out insurance policy because they thought the judge was going to die. I mean, he delayed giving the judgment so long. And eventually, I think Derry Irvin, the Lord Chancellor, sacked him. It's one of the few cases we actually sacked him. And the remarkable thing was that Harman was the grandson of another High Court judge. So there's a long line of judges in any event. The second point I'd make is just that monitoring the judiciary is actually very, very difficult because in most cases you adopt a carrot and stick approach. A carrot to induce the person to work better, a stick to apply sanctions. With the judiciary, you can't do that. It simply doesn't work. I mean, at best, if they're a full-time judge, you can say to them, well, look, you can't sit, but then they're still being paid. These days, you get appraisals, but I've even seen of cases where if the appraisal is negative, the recalcitrant judge will challenge the appraisal. So you're just creating problems, for yourself. The point that Simon makes is a very good one, that you do need leadership from the top. And I think increasingly people are beginning to realize that really those that manage the lead judges have to provide some kind of assistance and to be there to simply facilitate the writing of judgments, diction and the like and so on and so forth. But it is a very, very difficult point to deal with. On the question you've just asked me, just very quickly, yes, I think legitimate expectations has possibly gone too far, because it is a juridical mechanism grounded in, the finest traditions of the common law, to be fair, to look at abuse of power. But as I say, it can be pretty erratic. And very often, judges on the same facts will take different views. Would I do away with it? No. Because I think the whole question of public administration, the whole question of abuse of power, which goes far beyond Wednesbury unreasonableness, you've got offshoots like occasioning moral detriment, equality of treatment. There's a broad range of abuse of power areas. And I think all of these require the administration to act in accordance with the law. And where that doesn't happen, there are even cases now, which is steadily used to say that even rudeness in a court of law, there was a time when, in fact, judges appear to think that they have the right to simply be rude. Well, sadly, and the others have said, no, that's not right. The public law requires people to treat each other with decorum and respect and so on and so forth.
Thank you.
So I think it's absolutely right that we do have this notion, but applying it in a consistent and intelligible and predictable manner is a difficult question.
Thank you. Just Fayad wants to say something on this.
Short points. In contract, you have enforcement rights. You have enforcement rights in respect of various forms of estoppel. All of those are trust and contract rights. In respect of constitutional law, I think Pomponet got it right. It must be clear, it must be unambiguous, it must be free from ambiguity. And I think if the state makes a promise, it must be held to that promise. And there are enough safeguards within the parameters, like no election manifesto promises and all of that, that will put a curb on it, expand it beyond its present limits. Pomponet is good law, it is correct law, and it is a law by which you should stand by.
Thank you. I'd like to stick with the TNT team. We're going to move questions. Very good question, I think, probably from an English contributor. Biggest challenges facing the bar today and in the future. Keeping it to the most relevant and most serious. Ravi, what would you say from the Trinidadian perspective, looking at the profession as a whole, was the biggest problem?
I think the biggest problem we face right now is, in fact, delay in the system. When you look at the average length of time it takes for a trial to come up in the criminal courts, it's 6 to 8 years. You have a backlog of 500 plus capital matters, which means that those are persons in custody with no accounting for the number of non-capital matters in the backlog. In addition, it seems as though trials are taking way too long. You will have a 4 or 5 witness case that takes 2 and 3 months. So there's got to be a way to control time, to forensically control the length of the time that a trial takes. And secondly, you've got to do something about the backlog and the delays. And otherwise, we're just going to go from collapse into complete rot.
Well, that's a great answer. That's more about the problems facing the justice system, but that's a very helpful answer to that. What about the bar as a practicing profession?
The problem is the legal profession in the Caribbean is very close to becoming a business rather than a profession.
Thank you.
Heavily commercialized. Profit is the incentive, not service. And there's a problem also in respect of legal training and the quality of persons who are allowed to practice at the bar.
Yes,
we have enormous responsibilities. Ours is not a business, it's a profession. I think people have forgotten that. And the second thing is that what you have is a relationship, a very difficult relationship developing between members of the profession and the business community and the political community. And the issue of profit again comes to the fore, not the issue of service and the issue of loyalty to the rule of law.
But isn't the marketplace, I mean, first of all, you have more training than less training than before. And secondly, the marketplace provides its own forces to shape the service that the community deserves and requires. So what do you say about that?
The marketplace has to be regulated. This is a profession, like any profession, that has to be regulated.
Okay, so it comes to the same thing, which is we've got top-down leadership. So what we need to do, come on, the one thing I've noticed about the Caribbean states is that you've got more lawyers who have an important role to play in politics. Indeed, there's many on this stand who've done that. So, you should be obviously contributing to trying to shape the law so that there has to be regulation. What are the prospects of that?
The legal profession is a reflection of the political and legal health of the country. The problem is there has to be a more interventionist position on the part of the Law Association in respect of NGOs and most of all in respect of governmental authorities, where discipline is encouraged, as the case may be. Right. And that is an issue which the profession has to come to terms with, and the profession has to take it by the scruff of its neck and demand more invasive powers.
Well, that's very interesting.
In respect of the profession.
Well, thank you. So, lack of regulation. Can you pass it down the line? I'd like to hear from Mr. Guthrie first, and maybe Tom. We have plenty of regulation in England. So, the question was the biggest challenges facing the bar today, or maybe we'll start with Tom. What do you see it as?
I mean, personally, I think access to justice is the main concern I see for the sort of Bar of England and Wales, and really under threat by the Ministry of Justice itself and the savings that the Ministry of Justice are imposing. I mean, I'm not a criminal practitioner, but I'm married to a criminal barrister, and so I'm acutely aware, and perhaps more acutely aware than even if I was a practitioner in criminal law, from what my wife tells me, of the problems facing the criminal bar. There's been huge cuts to the criminal aid budget in England and Wales, cuts to professional fees. In civil law, you've got the increase in court sort of issue fees. Employment Tribunal...
Just to stop and tell people, and now if you issue a claim for over £200,000 sterling in the UK, that's the top tariff, it's £10,000. It used to be £1,000, and before it was about £150 about 10 years ago, so it's gone up very quickly.
And when I'm wearing my employment law hat as well, in the Employment Tribunal in July 2013, they introduced fees for issuing a claim in the Employment Tribunal, and that saw a 60% decline in all employment claims that were issued. Now, that dramatic reduction in itself, I would suggest, means that the fees are probably too high to start with. But one reason that they introduced the sort of fee was to weed out what they perceived as vexatious claims in the Employment Tribunal. So disgruntled employees trying it on really with their employer. But there's been no discernible, the statistics show, there's been no discernible change to the outcome of cases. So it clearly shows that meritorious cases are just not being proceeded with because of the fees that have been introduced. So for me, I think it is access to justice.
Thank you. Vinda, did you want to say something?
Yes, we used to have the highest per capita funded public litigation in the world, 1.2 billion per annum. In my undergraduate days, I learned that the law, like the writs, is open to all. I recall that now as with some, sadness, because the one thing which is clear is that it isn't open to all. And the employment case is a very good case because you walk into any employment tribunal building and the rooms are all empty. And there's been a dramatic fall in the number of cases that are going through. The £250 that's been charged by way of fee is simply beyond people. So, I mean, it's a catastrophe. And as I understand it, there's now a challenge, I think, before the European Court of Human Rights, that the imposition of fee does actually militate against Article 6 of the right to a fair trial.
Fantastic. Okay, well, thanks for that. I'm going to move topics, and we've got a question here, which is what are the disadvantages of agreeing to arbitration? Obviously, that's in the civil context. And I think I'm going to start with that, and then we'll pass it around. I'm tempted to pithily say none. But I don't think that's the purpose of the question. I think the question really is a provocative one deliberately. And one could, of course, turn it the other way around. What are the advantages of agreeing to arbitration? I suspect the short answer is it's horses for courses. But there are factors which have an effect. I think it's very important, though, to be fully aware of it. I think someone like Trinidad and Tobago should be at the forefront of this form of awareness. It's an exportable product. When I went to St. Petersburg to do some lecturing in the International Legal Forum, we had basically all of the senior justice ministers around the world competing for a multi-billion pound or dollar business because the litigation services being offered, there were competing bids by Russia, France, and the UK, and others. But it's such an important business, apart from we're dealing with constitutional security, of dealing with the safety of people living lives properly in this country, which of course is an imperative. But a strength, or a sign of strength of society, is that you're able to contemplate other issues, other factors. As you get richer, as you get more secure in your own independence and in your role in the world, so you have to look to other achievements, not merely constantly trying to have a row or a fight about some constitutional provision, because hopefully not the whole world doesn't revolve around constitutional provisions all of the time. If you have commercial activity, you're trying to save 400 jobs in a factory. This is of a very pressing need for people in your society. Not everything has to be do or die on the beaches in some constitutional provision. You have to deal with getting by in society and progressing in society. And so arbitration offers you a fantastic location. Think of your geographical location. Think of also the meeting of your languages and your cultures with an English spoken here, an exportable, tradable product. And really make use of that as practicing lawyers. So my view is, having represented Russians and we've seen what's been happening in Russia over the last few years, is that there is this consciousness of international security in litigation is of a very serious impact. We have instances whereby maybe 3 years ago, the view about litigating within Russia was a completely different view about litigating now. In the arbitrage courts in Russia, you might have been able to succeed, you might have been able to have a secure result. You might take a very different view to that now. So this neutrality of arbitration, don't overlook it. However, I'm asked to just kick off on the disadvantages. I think you could say that limited challenges are a potential disadvantage. In the Arbitration Act in England, you've got two routes, which are serious irregularity or a point of law. So if the arbitrator has simply got the facts horribly wrong, you might actually be stuck. And you've got to try and turn it in somehow to one of those two gateways to challenge it. Cost you have to pay for your judges, but in some cases, obviously, there's a lot at stake. As we've heard from Tom, the cost of litigation in the UK is going up anyway. Pro-publicity, well, you can take this two ways. Either what you want to do is you want the openness of open litigation to act as a lever in order to make a defendant that should be settling a bill, make them settle it, because behind the closed doors of arbitration, they might feel that they can just play games. On the other hand, it can encourage commercial activity and does have this enhancing effect, because what you can do is you know that if there's going to be a dispute, you can resolve that dispute in a confidential and secure environment. And of course, everybody might be playing with the same confidential information and value. So there's lots more that one can say, but I don't want to steal all the best lines. So do any other views over here about advantages, disadvantages of arbitration on a macro scale, and I think as the question had in mind, on a micro scale? No? Or not? Lots more that could be
I can't let us be underrepresented on this issue. I agree with everything you have said. The difficulty that we have in arbitrating in small jurisdictions is some clients get the impression of Solomon justice. In other words, you have arbitrators where there is a perception, and it could be absolutely wrong, that somehow the arbitrators feel like giving both sides something and settling the matter on that basis, and that doesn't go for confidence. And that is the issue. On a larger note, I'm all for the fact that the taxpayer and the ordinary man in the street should not have to pay and put monies into a legal system to support large energy companies and large multinationals, as the case may be. That should be funded as amongst themselves and decided in a specialist forum that gives you quick access to justice on an agreed location with an agreed choice of locals.
Yeah, that's a really great point. And also speed and control are very, very important. By the way, the good news is if you're very worried about onshore arbitrators and how it might be perceived, we can help you with that, because we provide a great deal of arbitration facilities. Well, of course. Anyway, but I think that speed and control are absolutely key. You can't criticise, half an hour ago, a system that has 5-year Court of Appeal judgments waiting, and at the same time be blind to the advantages of being able to control speed within arbitration. I would like to just do a pitch for Jeff, because I think he did a 1 week, $1.8 billion arbitration when I think he was sitting as one of the arbitrators a couple of months ago, and it was just right at the cutting edge of worldwide arbitrations in the capital markets, and it was a phenomenal achievement. Right, okay, I think we may have time for one question. Then I want to throw it out to the floor for 5 minutes, and then we'll wrap it up, I think. And it's back to public law. How your public law experts, this question declares, I'm pointing over there, what improvements could be made to the practice and procedure of judicial review applications? Don't be shy. A lot of listeners back in their kitchens around Trinidad and Tobago with bated breath about this question.
Well, I've just got one small experience from this part of the world, not here, but in Antigua,
where an enormous amount of effort went into the leave application, when I think I would have expected leave to be granted by a judge having read the papers for 5 minutes. but we spent 2 days arguing whether that leave would be granted. And by the time we'd done that and leave was granted, we had to wait for another several months before we actually got the judicial review proper. So if that is something which is not an entirely single episode, then I think that the rolled up hearing of leave, and if leave is granted, the substantive hearing to follow more or less at once would be an improvement.
Okay. Could I have a TN2 view? Maybe Ravi or Mrs. Stalick first and then back to Fayad. No? Okay.
We have in this country a dual system, the constitutional motion and the judicial review. And for those of us who practice at the public bar, we opt for constitutional motion because you don't need leave in respect of that. And judicial review could be very, very time consuming. And the second thing is that many of the reliefs which you could have formerly sought under a judicial review application, you can now get under a constitutional motion. For example, Papanet establishes the issue of legitimate expectation, which is really a judicial review ground, so to speak, as a protection of law point. So there's the conflation of them. The third thing is that many years ago, we did a case called Sumaya Mohammed, in which we conflated, for the first time in this country, a judicial review matter in which we applied for constitutional redress, and that was permitted. And finally, we have a wonderful piece of law on judicial review. It has really opened up the system, and it's really the fifth estate, if you want to call it, press before the estate, because there's always a wonderful opportunity to hold governments and public authorities accountable for their actions.
Thank you for that. Yeah, Tom.
Yeah, I mean, just really a practical consideration, going back to the question. I mean, to use the example of legitimate expectations, about 25, 30 years ago, you could have probably fit all you need to put about legitimate expectation cases in a footnote in the textbook. Now, today, we are overwhelmed by cases, just legitimate expectation cases. I think it was referred to earlier as an explosion of cases. And so, practical consideration, certainly over in England and Wales, is the administrative court is just overrun with cases. There are too many cases, not enough judges. And so what has happened in England and Wales is we've seen a lot more cases being sort of all filtered out at an earlier stage. You see a lot more cases now being decided by tribunals as opposed to judges sitting in the administrative court. And also, to pick up on the point we're making about access to justice, fees have been introduced as well to wheedle out what are perceived to be sort of the potentially unmeritorious cases.
Well, it's actually it's now more than 50% of all litigation in the UK is judicial review work. This, when the last day of the Second World War was being fought, there wasn't a single case. So it is an absolute explosion of a new creation. Okay, thank you very much indeed. I'd like to thank the panel members very much indeed. And I want to now... Yep, you can give a clap. Go for it. Thank you very much indeed. Now, but actually we're not done yet, because I want to throw it back to you, who've been listening and contributing patiently. But now is your chance to maybe ask one or two more questions directly, or alternatively state something after one of the answers that you've heard to those questions. Anybody like to volunteer, please? Thank you.
Just a comment on the issue of delay in the delivery of judgments. I'm a High Court judge. I don't think I've ever had a judgment that was outstanding for perhaps more than a few weeks. And that's really because at the end of the day, it's a matter of pure discipline. And I do think that the approach of the bar perhaps is a little too timid in addressing the judiciary on the issue of delay in the delivery of judgments. There was a Constitutional Reform Commission sometime, I think it was last year or 2 years ago. I actually presented a submission in which I suggested that there should be some kind of withholding of some part of a judge's salary. Well, of course, it didn't go down very well with my colleagues.
Funny that.
I think I was accused of bringing the judiciary into disrepute when the paper was published. But there has to be accountability.
Yeah.
At the end of the day, all of us are lawyers. We know if you put something down for a few weeks, it's very difficult to get back to it.
Absolutely.
And we're not doing magic. We're basically doing legal work.
Absolutely. And these days, with skeleton arguments and electronic passing of information, so the bulk of the facts can be actually taken quite acceptably from documents that you're given, chronologies and things like that, it should be possible to put these judgments together quickly.
I think it is possible.
But do you know what? I very much would like to hear your view. What most practicing lawyers are nervous about. I had to answer with Tom this case. We've been waiting for 1 month, and we won't name names, but while we've been in TNT, we've had a phone call from our senior partner instructing us on this colossal case, who said, should we be chasing the judge for the judgment? And actually, my view, see, English lawyer Theo Solly there looking horrified at the concept, quite rightly in my view. The nervousness of practicing lawyers is that even subliminally, that a judge might be negatively affected by the person who puts their nose above the parapet and dares to say, would you mind getting on with the judgment, please, Judge?
I think that entirely misplaced, quite frankly. I think what has happened is because people are not held to account, because judicial officers are not held to account, they basically get away with just, I don't want to say laziness, but just get away with dilatoriness.
Yes, so if...
They just put it off.
In practical terms, are you encouraging an informal or a formal approach?
I think the time has come for a more formal approach.
So somebody to list an application before a judge in a judge's court to ask the judge for directions as to when the judgment might be expected?
There are very simple ways I think we can insist, and I think a part of our judicial code of ethics does suggest that you should actually fix a date for the delivery of judgment. And if you do, and that puts the judge under some kind of timetable to just do what he has to do. A judge's role is to decide. If you're not deciding, you are not doing your judicial work. You don't care a thing. So no matter how much time, no matter how many submissions we invite, no matter how many hours we put into the hearing of a case, we are not done until we deliver the judgment.
Thank you, Judge. That's an incredibly helpful contribution. Can we hear from Mr. Solly, who wants to express something?
Singing in England and Wales, firm Sheridan's, and a number of points come to mind. Certainly in relation to that, one of them is that one of the advantages of arbitration, I understand, is that you can sometimes request a judgment to be provided within a specified period of time, and that's certainly an advantage to the parties then moving forward in a dispute of that kind.
Back to arbitration, you can say, I don't want to have a reasons, I just want a decision. But, or I want to have no appeals, or I want to have a limited reason decision. You can, that's the cool thing about
to the parties in that way, but I do also the Privy Council work a lot with a lot of the attorneys here and work closely with Three Head Court, and I'm often advising our clients in relation to judgments from the Privy Council that they do take time, and they often come several months, if not 2, 3, 4 months after the decision, when there's a lot at stake, and there's no prejudice, I don't believe, suffered to the parties as a result of that in any way.
But there's a very big difference, isn't there, Theo, between if you get a case to the Privy Council or the Supreme Court, it has had to be qualified, certainly as a Supreme Court case, as a case of national importance.
Yes.
And so it's not just your case that's affected in the facts of your case, but possibly affecting the shape of the law in the common law world.
Very much a burden to parties in sort of litigating, and but what's really important is obviously the energy that flows from lawyers at that junior stage, being able to feel that they can challenge those, pursue those actions in the judiciary right through to the highest court, and their ability to adjudicate on what become the very important issues there. It's obviously clear from what we've been discussing today, what's critically important is the independence and integrity of a judiciary. And I just wonder out there something that a maxim my father told me, and it comes to something we've already spoken about in the panel today in the CCJ, as to whether the grass is greener on the other side.
Absolutely. Yeah.
It was inspiring. It really was. I'm going to, in a minute, invite Peter Knox and Raj to come forward. I think they should have the last word. So this is the last you'll hear from me. But I do want to say, because I think in no small part, I'm inspired by something that Ramesh Maharaj said earlier this morning about it not just being looking back over our shoulders, but it being about taking the law to where it has to go. The fact that that falls to us, and in some cases our clients, to be brave to do that. I would have thought that on the question of what is the biggest challenge for the profession, certainly from where I sit and looking out in large parts of the world, it's a challenge. Many of the challenges we heard about, the facts are important, have changed over time, but one challenge hasn't changed over time. It's the challenge of our profession to overachieve, to attract more than our fair share of the best people. You heard from the judge, we know that right people can make all the difference in the world. I'd just like to ask a question and then maybe say one thing that will perhaps inspire some of the students, younger lawyers in the room. I just want to ask on a showing of hands, how many of you were, like me, a university student in the 60s? Wasn't it great, James? We thought we were revolutionaries then. You missed all that. Sorry, nothing I can do about that. But I would argue that these are revolutionary times in the profession. Globalization, technology, again, contribute to that revolution. I can't think of a more exciting time to be coming into the profession. But it is about people, and it is about hard work. And again, I said it was a privilege and an honor for those of us who've made the trip from London to be here with you. I said it was also fun, and it has been. And now I just want to say it's been inspiring. So this is the last you're going to hear from me, but before I sit down, I'd be remiss if I didn't, and I'll ask those of you who would do it with me, thank all of our speakers for their contributions during the day. I want to do that first. And then I want to say a special thanks to the audience. If you've stayed the course, as so many of you have, you're to be congratulated. But again, it's important to us that this dialogue continues among all of us, and I'd just like to say a sincere thanks. I hope my speakers will join me in saying thanks to you, our audience. To sit down now, I'd invite Peter and then Ramesh, and I think we'd also like to hear from the network, last word, which I'll leave to Ronnie. But Peter, if you could take the podium. Thank you very much.
I may echo what Jeff Golden has just said. I think it's been a marvellous conference, but it has required some stamina, I would imagine, for the listeners. And I think what I liked about all the talks, at least those in which I was in the audience, they were easy to follow, but at the same time interesting and comprehensive. That really is the golden aim of the advocate. We went back not only through the legislative history of Trinidad and Tobago and the development of its common law going back to 1498 and the Spanish law, but back even further than the English law through the Bill of Rights in 1689, Magna Carta in 1214, and even the Norman Conquest in 1066. But I would like to go back one stage further to about 800 BC, to something written, or sung more likely, by the ancient Greek poet Homer in the Iliad, because it seems particularly apposite to what we heard today. Now, when I was a student, I was a classicist, so I had to read Homer in ancient Greek. And I always remember reading this very banal line and thinking, well, I could have written that too, but it's stuck in my mind. And basically what he said was this: there are many things that can be said on both sides of the argument. And I thought to myself, well, I could have written that, but anyway, I think today showed the truth of what Homer said. For instance, in Papinet, we heard of the diametrically opposed views of Lord Dyson and Lord Brown on the law of legitimate expectation. Basically, Lord Brown said, I don't know what you're talking about. And again, how those two same judges locked horns on the question of the fair-minded observer in the Belize marketplace. Again, Lord Brown loses and says to Lord Dyson, I don't understand how you can possibly come to that conclusion. And he would have said it more or less just like that. And then again, in Dumas, we heard how the High Court and the Court of Appeal in Trinidad and Tobago came to diametrically opposed views on locus standi. We heard how, from Rob Strang in the Belmarsh case, Lord Hoffman disagreed on whether there was sufficient justification for detention without charge from all the other law lords. And Lord Hoffman seems to have made a speciality of dissent because he was also the dissenting judge in the two Bahamian cases we heard about from Tom Rowe. One where he was in the minority of 3-2 when he lost then when the same case comes back but with different people, he's again in the minority trying to stick up for the original majority decision in the same case. Astonishing stuff. Again, I might say that was a case I managed to lose. We heard how in what one would have thought were fairly clear cases, the Privy Council took fundamentally different views from both courts below, both in the case involving Sir George Mitchell and in the St Kitts election. We also heard in the Law of Damages how the Privy Council shamelessly, as it seemed to me, chopped and changed on the burden of proof on the question of mitigation of loss. And indeed, more generally, the great difficulties facing the courts in Trinidad in assessing general damages in personal injury cases. And how, finally, on the problem of vindicatory damages, we heard what the problems are. I think, reading between the lines, what was being said by Hafsa and Rowan was, no one quite understands Ramesh and my case of Alain 40. It may just be the way we managed to argue it. But it's a very difficult area, the whole notion of vindicatory damages, because I've never quite understood in real life what the difference is between vindicatory damages and exemplary damages. And I seem to remember in Alain 40, Lord Wilson saying, what is the difference? And we said, we don't know. And more generally, we heard also, how should we change things? Surely, now, and I think it's especially interesting talk from John Jeremy's, surely now is the time for the courts to have a more interventionist role in investigating what happens in Parliament. Now that, of course, is a revolutionary notion, a very important notion, but one can see possibly the beginnings of some movement in that direction in the Toussaint case and indeed in the St Kitts election case. And then we heard from Sir Fenton Ramsay, if I may say, magisterial speech in identifying what improvements do need to be made in certain parts of the administration of justice in the Caribbean. And I, for myself, found it an absolutely gripping speech by a man who knew what he was talking about. And then finally we heard, again, I think a very interesting point from Jeff Golden, the improvements that need to be made in resolving financial disputes. And the simple point made by Jeff Golden was simply this: if you have standard form agreements which are used throughout the financing markets, if a judge makes a wrong decision or a slightly odd decision on that, that zooms around the markets and there's chaos. And I think Jeff's proposal, which I hope is taken up, that in England we have a specialised financial division, effectively of the Chancery Division, a bit like a patents court, then I think that would be a fine thing. And it obviously makes considerable sense. And finally, but not least, we had Tom Rowe's fascinating talk on dissenting judgments. For myself, I am profoundly in favour of them. The obvious disadvantage of judgments in my committee is that they're compromises, they lack all character, and the great thing about the dissenting judgments, Tom Rowe mentioned one, but there's a great dissenting judgment in Rudall, the infamous case of Rudall. You read Lord Rogers and Lord Millett's dissent, it is quite something. But the dissenting judgments, really, I think that tradition is a wonderful thing. And I think it does one really important thing, which you never get the impression of from the European judgments, which is a sense of openness. These judges, they're all debating. And that, I think, is how lawyers should be. They should be open and they should debate. All this, I think, therefore shows that a lawyer, any lawyer worth his salt, should never give up on a case where he has at least a reasonable argument. You never quite know. It looks pretty hopeless when you're at first instance and the judge is looking, I don't know what you're talking about, even in the Court of Appeal. But then you suddenly get up to the Supreme Court and they're all on your side all of a sudden. As long as you've got one sensible argument and you keep the focus on that, I think you've always got a chance. Finally, I would like to echo one thing which Fayed Hussein said in the very interesting talks at the end. In the end, this is not a business but a profession, and you're here to serve your client and to do everything you possibly can within the rules to get the right result for him. That, I think, is the one thing all students, all people in the profession, must have at the heart of their job. We are in a position of the utmost trust. It is the most miserable thing for most people to have to go to law. The one thing they need to know is they must trust their lawyer, absolutely. We all make mistakes from time to time. That probably doesn't matter. Lord Donaldson once said, I think, the great thing about professional negligence is hardly ever we're normally saved by the law of causation. But that is the most important thing to remember. It doesn't matter too much about the odd mistake. Everyone will make the odd mistake. The main thing is to do the right thing for your client and to be totally straight with them. I hope you've enjoyed today's conference as much as we all have. Thank you very much.
Peter.
Sorry.
I do not dissent from anything Peter just said. I would like to thank Mr. Peter Knox and Three Hair Court for the time they have taken to come here and to visit us in Trinidad and Tobago to be part of this project. I am sure that Trinidad and Tobago has benefited, and in particular, lawyers, judges, and law students who are going to be the future lawyers of Trinidad and Tobago and in the Caribbean. I think that there are many challenges facing the legal profession, and what we are trying to do with this group is to try to give more information to lawyers and trying to make the public also understand law better. And I think if we have succeeded in doing 1 inch of that today by this project, we would have succeeded in our mission. I want to say one thing about a point which has been raised in the question series, and that has to do with delayed judgments. And I agree with Justice Govin that the bar in Trinidad and Tobago is too timid. The bar in Trinidad and Tobago, to a great extent, is subservient and sometimes sycophantic. The legal profession, the bar, has to be strong, fearless, and independent. And the time has come in Trinidad and Tobago for the bar to challenge matters which are happening, problems which are happening, even within the judiciary. The administration of justice is one of the most important aspects which have to deliver justice to individuals in Trinidad and Tobago. And one has to face facts. In the Court of Appeal, there's a matter which is pending for over 5 years. Mr. Hussain knows about it. Am I correct, Mr. Hussain? Over 5 years. And I have been studying what to do. Letters have been written, statements have been made, the judgments have been given in 6 months, and no response, and if there's a response, no action. So I have thought about something that I'm going to do. I'm going to file a motion before the Court of Appeal to go before the same judges, and I'm saying that the inherent jurisdiction of the court demands that you tell us, when are you going to give judgment? When are you going to make the order? Because it would be an abuse of process if this thing continued. And delayed judgments in Trinidad and Tobago can be a major problem for people. As Mr. Hussain has said, people have died without getting their judgments. And I think that the Law Association of Trinidad and Tobago should consider taking up some of the issues which are facing the public with respect to pro bono work for lawyers. Lawyers must give something to the community, and we should, like in some countries, give some of our time, make it mandatory to give some of our time and skill to members of the public in taking up some of these matters. So I know you have had a long day. We have all had a long day. But I would like to thank everyone who participated in making this possible. I would again like to thank the Hugh Wooding Law School, and can I call upon Mr. Bissessa to do the vote of thanks?
Thank you very much, gentlemen. On behalf of the Trinidad and Tobago Legal Network, I wish to express our gratitude, our profound gratitude, to the principal and faculty of the Hugh Wooding Law School for inviting us into their facilities and making them available to us. I am sure you'll agree with me, it's the appropriate environment. It is a wonderfully closed, it's a lovely environment for exactly what we are planning to, what we are doing. I wish also to thank the panelists for firstly agreeing to attend and be panelists, and secondly, and more importantly, offering their contributions so frankly and unafraid. And for those reasons, I think they deserve our gratitude. Of course, our thanks go to you, the audience, whose contributions themselves are not unnoted. We, of course, have audiences outside of this room, and I wish to also thank them for their attendance and no doubt their enthusiasm for being part of these professions. I wish to thank the various contributors to the TTLN, whose financial and other support has made this particular event possible. I wish to express our gratitude to them for their loyalty and, in fact, their faith in us, because this is, in fact, our inaugural event. I also wish to thank our event planner, Ms. Laverne Henry, for her spirited and sterling work in putting this event together in a very short time frame. We are very grateful for her expertise and her professionalism, and we've all learned a lot from her. Ladies and gentlemen, in assessing how effective the TTLN has been in performing its very first function, I'm reminded, as I was waiting for my opportunity to speak with you, that our mandate is really twofold, as identified in the banner, which is very proudly displayed: promoting legal education and scholarly legal debate. I will leave up to you to assess whether or not we've achieved our mandate and whether or not you wish to be part of us in the future. So once more, thank you so much for your presence and for your enthusiastic participation in this hour debate, and I wish you well for the rest of the afternoon. Thank you very much.